All right, it is December 12th, 2025, 8:09 a.m. I'm going to go ahead and call the full board to order. Can we have roll call, please?
Yes, good morning, everyone. Dr. Zaffron,
Present.
Dr. Farmer,
Present.
Mr. Kokonos,
Present.
Mrs. Barnes,
Present.
Dr. Bhatia,
Present.
Mr. Crane,
Present.
Dr. Deloche,
Present.
Mrs. Del Rosal,
Present.
Dr. DeStefano,
Present.
Dr. Green,
Present.
Mrs. Harrod,
Here.
Dr. Jones,
Here.
Dr. Martinez,
Present.
Mrs. Morgan,
Here.
Dr. Naidu,
Present.
Dr. Quinones,
Present.
Dr. Tibbles,
Here.
Mrs. Troncoso,
Present.
Dr. Vanderwide.
Yes, sir.
All right, all present. You may proceed.
Great, thank you. As we always do, we'll start out with our mission statement. Our mission is to protect and enhance the public's health, safety, and welfare by establishing and maintaining standards of excellence used in regulating the practice of medicine and ensuring quality health care for the citizens of Texas through licensure, discipline, and education. As far as the board member report, the next item on the agenda, the only thing that I will briefly mention is we had gotten some complaints from physicians about prescriptions that pharmacists were asking questions regarding the appropriateness of the prescription because of the specialty of the physician. We had a conversation with our partners at the pharmacy board to make sure that there was a clear understanding that as physicians are not limited by specialty as to what they can prescribe. And there was agreement on that. There is discretion, of course, from a pharmacist to not dispense if they feel like they don't have enough information or there are concerns, other concerns that are out there, but certainly not from the standpoint of the physician's specialty. And I would anticipate a joint statement between the medical board and the pharmacy board going out, clearly reiterating that, so there's no confusion, since it's becoming a little bit more prevalent out there, just to make sure that it's clear what the rules are regarding prescribing and any kind of limitation from a specialty standpoint. So again, it's something that we've just heard a little bit more often about, and we wanted to make sure that we address that jointly with our sister regulating agency. All right, with that, I will move on to item number 3, consideration and possible action regarding dispositions below minimum guidelines. There's no items there. Under item number 4, consideration and approval of mediated settlement agreed orders. There are 3 items there. Is there any extractions or recusals on item number 3? Sorry, item number 4. Seeing none, is there a motion on item number 4?
So moved, Bhatia.
Second, Farmer.
Okay, what is the motion?
To accept.
To approve mediated settlement agreed orders?
Correct.
Okay, and it's been seconded by,
Farmer.
any further discussion? All those in favor, please say aye.
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 All those opposed, motion passes. Item number 5, consideration and possible action for remedial plans. Under there is administrative rules, crime laws, which there's none there, impairments where there's none there, peer review state action, standard of care, and unprofessional conduct, which there's none there, and late orders. Are there any recusals or extractions on agenda item number 5?
No.
Seeing none, is there a motion on agenda item number 5?
Dr. Zaffron, I'll make a motion. Michael Kokonos, consideration and possible action for remedial plans under administrative rules. Peer review,
Oh, go ahead.
All of them.
standard of care, unprofessional conduct, there's none. Late orders.
Okay, the motion has been made by Mr. Kokonos for
Second.
passage of agenda item number 5. Is there a second?
Second, Quinones.
Any further discussion? All those in favor, please say aye.
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 All those opposed? Agenda item number 5 passes. Number 6, consideration and possible action for agreed orders. There is administrative rules under there, which is none. Crime laws, there's none under there. Impairments, there's none under there. Peer review state action, standard of care, unprofessional conduct, and late orders. Is there a motion on agenda item number 6 if there's no extractions or recusals?
Quinones, motion to accept all consideration and possible actions for agreed orders, item number 6, all items.
Is there a second?
Second, Bhatia.
Second by Dr. Bhatia. Is there any further discussion? All those in favor of agenda item number 6, please say aye.
Aye.
All those opposed?
Aye.
Agenda item number 6 passes. Number 7, consideration and approval of modification request, termination request orders. Is there any recusals or extractions on agenda item number 7? Seeing none, is there a motion on agenda item number 7?
Motion to adopt the considerations and actions for that agenda item. Barnes.
Coconos, seconded.
We have a motion that's been seconded. Is there any further discussion? All those in favor, please say aye.
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 All those opposed? Agenda item number 7 passes. Under agenda item number 8, there's none there. Under 9, there's none. Under 10, there's none. Under 11, there's none. And under 12, there's none. Agenda item number 13 is not due to come up until 9 a.m. And number 14 is not due to come up until 9:15 a.m. So we'll go to agenda number 15, which is our executive director report.
Yes, thank you, Dr. Zafran. Good morning, everybody. Merry Christmas, happy holidays, and upcoming Happy New Year.
Merry Christmas.
Yeah, thank you. So for the report today, we want to try to focus on our budget and kind of what we're looking at coming up for already planning for the 2027 legislative session. And it's hard to believe that it'll be here before we know it. So I'll turn it over to Joey to talk a little bit about what our budget's looking like today in our current biennium, and then we'll talk a little bit about what we're already gathering as far as information for what we'll present to the legislature in the 2027 session.
Thank you, Brent. Good morning, board members. So by the end of the Q1 for fiscal year 2026, revenue collections were just over, let me find my notes, $9.4 million. This is $700,000 more than what we had collected last year at this time, 8% increase. So overall, our budget is looking phenomenal for the fiscal year. Our expenditures are still a little over budget, but that's mostly in part because we have not collected all the revenues we anticipate to collect by the end of the fiscal year. We are projecting to meet that requirement, so expenditures overall should be fairly well by the end of the fiscal year. We are also still in the middle of our financial audit with the Comptroller's office. It's going a little bit longer than we expected, but that's okay. Once they finalize the report, I'll have more information that I can present to the board on that and the findings and actions to take. As Brent was saying, we're also in the process of getting ready for the legislative appropriations request for our 90th legislative session. I've already met with members of the leadership team and I've gotten some initial feedback on what the requests are going to look like. So over the next 3 months, we will be working on getting more detailed information so we can kind of see what that final request might look like. The legislative appropriations request isn't due until the end of July, early August, depending on what the Legislative Budget Board is requiring from us. So we have plenty of time to gather as much information as we need to prepare that document moving forward. Just to kind of highlight some of what the input has been from the leadership team, and I also provided that as a document for you. The biggest request, obviously, is addressing and making sure that we're able to retain existing staff. So that's most likely going to be our highest legislative appropriations request. Generally, that's about $5 million ask per fiscal year that we've had over the last 2 bienniums. So I'm anticipating that's going to be a similar ask. We are doing a compensation analysis to complete that, and we should have that done by March for further discussion in our March board meeting. The next request is going to be to address high turnover positions. As of now, that continues to be our attorney series and our nurse investigator series. And then the next largest request from the agency will be to address information technology resources. We have received very little funding over the last 2 bienniums to support ongoing costs, and our IT ongoing costs have significantly increased over the last 5 years, almost to about 30%. We've provided that information to the legislators, but they still haven't heard our request for that. And we're also receiving feedback from our current vendors who provide us with those resources that they're expecting costs to go up at least 10% over the next year or two. So we're really going to push hard this next session to try to address that deficit. Then also too, as we modernize our efficiencies and process within the agency, we'll be looking at trying to acquire additional IT resources, softwares, licenses, things like that to better improve how we operate within the agency and interact with our licensee population. So also too, just really quick to highlight some items. Currently, we are collecting anywhere from 65 to 70% of the revenues we receive. So we have plenty of bandwidth to go to the legislators and ask for more money that we do collect. And overall, we're kind of projecting just a back of the napkin estimate, maybe $20 million for a biennium request. That would be the max, and that falls within the bandwidth that we have available to us to ask for. So pending any questions or further discussion, I will hand it back to you, Brent.
Thank you, Joey. Like you said, one of our biggest costs that keeps going up from year to year are the increases in the cost for hardware, software, licensing fees, just things that vendors charge us to do some of the things that we do here. And again, that doesn't always, I guess, we don't always seem to get those funds that we request from the legislature to cover those increased costs. So one of the things that we had talked about doing is similar to what we have with the Texas Physician Health Program, where there is a set fee that all of the licensees pay to pay for that program each year. And there's a cap statutorily on how much can be charged on it. And we're not at a point where we need to reach that amount. But we thought about asking the legislature if we could have a similar fee set for a technology fee that our licensees could pay. And then that way, if we know we have a year where the Microsoft licensing fees are going to go up 15%, we have an ability to adjust that fee up or down depending on what's going to happen with expenditures. And then we wouldn't have to go back to the legislature each time. And so some years the fee may be a little bit higher, some years it'd be a little bit lower, but at least it would kind of help keep our budget a little more manageable when it comes to those type of costs. So that is something that we're going to look at. And then also, just as our licensee population has grown, of course, our staff has grown also. But we've done a lot of good in catching up to where we needed to be over the growth of all of our licensees and the individuals that we have to serve. But there's still a little more room we think that we can go and ask for. We've asked for larger FTE employee increases over the last couple of years, and we have gotten, again, a decent amount of what we asked for. But this time, I think it won't be focused so much on additional staff, but it'll be in paying for the increases, the cost of living, and everything for our current employees. Because we do have great people here that do a lot of great work, and so we want to be able to keep them and retain them, and not have them stolen by other agencies that maybe have higher budgets than we do.
One thing I wanted to ask you is, with the possibility of one of our rules passing today, that will potentially expand licensure to a new population, and the licensure verification requirements that go around that is going to be obviously different, I'm presuming, a little bit more complex. And has our requests in the budget taken into account, or maybe possibly looked into the fact that there may be software that we need to be looking at regarding what that may look like? I'm presuming after the rule, if it passes, that would be something that we may want to take into consideration as to what that looks like specifically.
Yeah, absolutely. So yeah, we're going to take a look at that if we need additional software, or if we or staff to do the processing of those applications. One of the things that's been difficult, especially with like the international medical graduate rule and the alternate pathway that depending on what happens today, would be available to them. It's been hard to gauge around the country, looking at other states, how many applicants we're going to receive. So Texas is a very popular state. Anticipate that we have a lot to offer, and so people hopefully are going to be applying for this in high amounts. But depending on what we see, we'll be able to translate that into our request for additional resources as well.
Okay.
I think that kind of covers the main things we want to talk about on our LAR and our current budget. So happy to take any questions from the board members.
Brent, I do have a question. This is Dr. Farmer.
Yes.
You mentioned with the Microsoft updates and things like that. Did you say you were going to try and pass some of that cost on to the licensees, or did I hear that incorrectly?
So that's an idea, just like the Texas Physician Health Program, there's a set fee. So for example, the Texas PHP, it's capped at $15 per biennium is what they can charge for it. It may be something similar. It may be a maximum of $10 every 2 years or something like that. And some years we may only need $3 of it. Some years we may need more, but that's kind of what we were looking at to try to be able to make those adjustments from year to year instead of having to wait for the legislature every 2 years to make those increases for us.
But either way, they would have to approve one or the other. And
The legislature, yes.
yeah, so the idea is when we go to the legislature and ask them for this, it's a requirement that we have to obviously pay for this stuff. If we're not able to process paperwork and stuff like that, unfortunately, the licensees who, there may be investigations and stuff that are going on, it may take longer time because it's harder to have the documents and process the paperwork and so forth. So it's an idea to present as one or the other, either help us with meeting the budgetary requirements financially, or if there's a different way they want to do it by having a separate fee, then that's another idea that they can consider. So
Yes, and it would have to be approved by the legislature. It's not anything that we have the authority to do on our own.
Okay, thank you.
Yep, thank you. Any other questions? Okay, I know we have other items to get to, so that'll complete my report.
all right, thank you, Brent. Next item on the agenda is our medical director report. Dr. Schnava.
Thank you, Dr. Zafran, and good morning, board members. We have been working on the expert panel list, and we have been trying to recruit some more pediatric team members for the expert panel. I would appreciate if anybody from the board could could help us with some references so we can start reviewing the files and start vetting them. Other than that, there's nothing else to report at this stage. If you have any questions, I'd be happy to answer. Thank you.
Yes, and regarding that, the DPRC committee met yesterday and we approved a list of expert panelists that were up for consideration. So we're expanding that list, but we hope to, there are certain specialties that are obviously a little bit more difficult. Pediatric gastroenterology, pediatric cardiology, just some of the pediatric subspecialties. So obviously, if there's any interest from our licensees out there who meet the qualifications, we'd obviously love to be able to consider them. So thank you.
Thank you. Thank you, Dr. Zafran.
I have
All right,
a question. This is
yes.
I had made some recommendations for apparently a physician group that they have plenty of plenty in the pool, and they weren't going to take them under consideration. And so I asked the question if any of those that we have plenty of, so apparently it's family practice, they have plenty of pool in that pool. Is there any turnover? Does anybody drop off the panel? And I never got a good answer. I was wondering if the medical director could help us clear that up in my mind.
Yeah, and I can answer that too, Dr. Deloche. So we are folding Dr. Schnava into this role as we go. That list is kind of currently maintained by some of our investigations team. It's a list that changes almost day by day, and it is I will say the specialties that come up all the time, family medicine, emergency medicine, they're pretty well stocked with folks, and we don't have a tremendous amount of turnover. What they find is, some people respond very quickly and take the case and get the report turned in very quickly. And so we do tend to go to those folks over and over again and kind of keep those cases moving. We also, because we're using some cases with just one panelist, so those specialties where we don't have a shortage, we're doing pretty good. And then that has another effect on the ones like pediatric gastroenterology or hematology is one where those cases only come up a couple times a year. So you might send us somebody and we sign them up and we give them a case, and then they may not have another case for a year. And then by then we go back to them, we're like, this is something and then they have to reset their finance forms and their direct deposit and all of that. So the specialties we don't use very often continue to sort of be a little bit more of an administrative problem, whereas the specialties that we see every day, we're doing pretty good. So we appreciate all of the referrals. We reach out to all of them, but there are some specialties that we really don't need any more of right now. And I think as Dr. Shinava gets to work closer with that staff, we will have a better direction for what we need to come to you to ask for specifically. We've really focused on these very tough, hard to fill cases. They're almost one at a time cases, and we are limited by statute to what we can compensate for those. So that is also something we're going to be considering. If there's a way to pay a little bit more for some of these specialties that are very hard to obtain, we do have the ability to go. We did get a change in the rules that we can go in the statute, that we can go outside of Texas to another compact state. But again, are we recruiting them to be on the panel to review cases every month, or do we just need them to review one case that we can't get moved? So there are some logistics that we're going to be working on after we kind of get, we've got a couple other roles we're filling. We filled our ombudsman role. We're filling a business analyst role. And this is something that I'll be working with Dr. Shinava on personally as well. Probably more than you wanted to know, Dr. Deloche, but.
No, I appreciate it. And it's the underpinnings of what y'all do on a daily basis. And I don't deal with, I just know that when I've submitted somebody and that the panel was full, I just asked the question, does that panel ever fall off? I mean, if they've been on there 10, 20 years, I don't know. I didn't get an answer. And apparently it's complicated. I understand.
Dr. Deloche, sorry, I hope I didn't interrupt you, sir.
You're good.
I will personally look into this matter, and I'll revisit the panel, and I will see where it stands, and I'll revisit every physician panel member who's been there and the time span that has been there based on the certifications, qualifications, and there's some specialties within the panel, and I'll give you a report within the next few weeks, sir.
Appreciate it. Thank you so much.
Thank you very much.
Yeah, let me just kind of emphasize also that when we do go out of state, as Chris mentioned, that it is specifically a compact state, which we know has similar structures as far as approval and so forth. So,
yeah, and it's also rare. It's only if we cannot find someone in that specialty here in Texas to take the case. So we do not go out of state very often. But again, that's usually it's very, very sub specialized individuals that are not in the same, they can't be in the same geographic region as the licensee that we're looking into and stuff. So you have to meet kind of a pretty special set of circumstances for us to look to a compact state.
Yep. Okay, thanks, Dr. Shinava. With that, I'm going to go to item number 17, which is our public information update. Ms. Sloan.
Good morning, everyone. So today I just kind of want to revisit some items that I spoke about in my last update in October. You'll recall we discussed upcoming continuing education changes approved by the legislature. One of those changes concerns SB 31, the Life of the Mother Act, which is a later agenda item today. But this legislation requires the board to provide a free CE course related to pregnancy-related emergencies. The bill mandates that any physician who provides obstetric care and is applying for a license or renewing their license to complete this course as a condition of application or renewal. It's a one-time requirement. It's going to impact folks applying on or after January 1 and folks renewing after that time. As you likely know, physician renewals are staggered on a quarterly basis. So the first individuals that are going to be subject to this renewal requirement are those with the February 28th license expiration date. I tell you this because renewal notices have already been generated for those folks describing this requirement. So if you start to hear about it out there, it's out there. We are going to be sending additional specific communications to the physicians who've reported an obstetrics related primary or secondary specialty to us to make extra sure that they're aware of this requirement. We don't want anyone getting tripped up at renewal because they haven't completed this or weren't aware of it. There's also information already available on our website related to the requirement. Technologically speaking, similar to the JP exam, the course is going to be accessible through MyTMB. Once an applicant or current licensee takes it, the system will recognize that and will automatically remove it as a lacking item for application or renewal. So it should be really easy on the applicant or licensee side of things. Another new CE requirement we discussed in October was related to nutrition CME. As a reminder, the board is required to approve coursework for this. However, that's dependent on the recommendations established by the Texas Nutrition Advisory Committee, which was also established by the same legislation that created the CE requirement, which was SB 25. However, that committee has not yet been appointed by the governor's office. I have been in contact with the governor's office, though, and I'm told that those appointments will be out soon, potentially as quickly as this month. So more to come on that at a future meeting. The final item on CE requirements is the new mandate for health regulatory agencies to use a CE tracking system to ensure compliance. As you guys know, we're going to be continuing to use CE Broker for this purpose. We will continue to ramp up communication efforts, especially in the new year, about this requirement. As a reminder, anyone renewing after September 1 of 2026 will need an active CE Broker account, and all of their CE will need to be uploaded in it. We do know that CE Broker has been in communication with stakeholders like TMA, the Texas Medical Association, and working with them to help ensure they understand what the program is. And hopefully they'll help us spread the word to our physician licensees about CE Broker and the importance of creating an account. And also, obviously, TMA is a CE provider, so there's a good partnership that can happen there. In the next bulletin, we're going to touch on all of these things, as well as the HB 2038 application process. I know an item also came up in DPRC yesterday. So we should have a pretty robust president's message in the next bulletin edition. The timing for that next bulletin is early next year, so that we can have more information to talk more in detail about some of these new legislative requirements, and also so it doesn't get lost in inboxes during the end of the year shuffle. I think that is all I have for today, but if you have any questions, I'm available.
Thanks, Tori. And just one thing I would reemphasize, and I hear this a lot of times from licensees, the medical board is implementing the legislative requirements that are mandated for a lot of these CMEs. It's not something that we have discretion in. Now we are directed to provide the CME or to direct the licensees for other CMEs to be able to get it from somewhere else. This one in particular, we're supposed to be the ones providing it for SB 31. So that's something that we will vote on later on in the agenda today. So, and it's the same thing with the CME verification. That is also a statutory requirement that we are implementing.
Correct.
So once again, thanks, Tori. Any questions for Ms. Sloan? All right, seeing none, I'm going to go to number 18 is report of the physician assistant liaison. There's none there. 19, consideration possible action regarding pending litigation. Mr. Freshour.
Yes, good morning, everyone. My report is going to be fairly short today. As you usually hear from me, there's a number of appeals going through state district court on board orders that you've issued through the SOA decision-making process. In those cases, again, it's a substantial evidence standard, meaning if there's something to support the action of the board within that order and within that proposal for decision from SOA, that the courts will uphold the board's action. So again, we are prevailing on most of those. We have a number of them going through. Those are all fairly routine. Beyond that, there's a couple of other court cases that have been filed on various issues, but they haven't really moved forward in any substantive capacity. And quite often we get notice, hey, we filed suit and the lawsuit's put in the court, but we're not served the actual notice, which is a requirement before the board is required to respond. In those cases, when we get notice of a lawsuit, even if we're not served, what we do is we contact the Attorney General who represents us in all of those types of cases. And we have a couple of those, as I said, right now, but with nothing to report on. And beyond that, I'll be glad to answer any questions.
All right, thank you, Scott. Agenda item number 20 is just reports on automatic orders. That's a report, unless anybody has any questions, that's there for you to be able to consider and look, well, not consider, but look at. 21 is consideration and approval of orders to show cause. There are none in there. 22, discussion, recommendation, and possible action regarding approval of AccuDetox providers. I don't see.
Yeah, there's not specifically in the folder, but so this is, the legislature has passed a couple of statutes the last couple of sessions regarding AccuDetox. This is something that falls under the regulation of the Texas Medical Board, but there are other, license types that are able to do it besides just the licensees that we have. And part of one of the changes that came is it said that the board can kind of expand the pool of who is able to do the AccuDetox kind of at our for professions that we deem appropriate to do it. We have had some requests come in from some groups wanting their licensees to be able to do it. And so one of them has to do with occupational therapists and occupational therapy assistants. And so they are regulated by the Physical Therapy and Occupational Therapy Board, and also pharmacists and pharmacy technicians through the Texas State Board of Pharmacy. There is a training course that someone would have to do to be able to do that. They would have to have that underlying license, and they would have to apply with us to get that certificate to do AccuDetox. Again, the legislature has put a big push on wanting as many people as possible to be able to have access to this type of therapy. And so we did reach out to the PT/OT board and to the pharmacy board. Both of them came back and said they were, either neutral or had no concerns on expanding to their licensees being able to do it. And so we're bringing it to you guys as the board to give your approval for those four groups to be able to be added and have access to get the AccuDetox certificate. So again, it'd be occupational therapists, occupational therapy assistants, pharmacists, and pharmacy technicians.
Thank you, Brent. So before you is consideration for the approval of the AccuDetox providers, as stated by Mr. Carlton. Is there any discussion on that? Is there a motion?
I have a question on the AccuDetox. Is that an injection? Or,
no, it's not an injection, but it is an irregular kind of 5-point. It has to do with around the ear. And so it's kind of similar to kind of like an acupuncture type thing, but there is a specific training course they go to for that.
Okay. Just wanted to confirm. Thank you.
Yes.
Deloach, I have a question. So this would be, so they would have to get the certificate that we come up with after training, and the training course is already out there, or does that has to be
it already exists. It already exists. Yes.
For others, you just add these four, right?
Adding those, the other ones for
we already, we license social workers, professional counselors, licensed psychologists, chemical dependency counselors. The list goes on. We have a checklist on our website. So this is just adding to the types of people that could provide this service.
Okay, thank you for that clarification.
Specifically those four.
Yeah.
I'd like to make a motion to accept and or adopt those 4 specialties to be added for this treatment and training.
So motion by
Deloche,
Ms. Barnes,
second.
is there a second by Dr. Deloche? Is there any further discussion?
Thank you.
All those in favor, please say aye.
Aye.
All those opposed? All right, that passes. Number 23 is discussion recommendations and possible action regarding SB 31 continuing medical education. So as was stated earlier, there is a statutory requirement for the medical board to provide CME on SB 31 to providers who participate in managing these kind of things with the mother. I guess one of the questions I was going to add, but before you is the proposed CME, which was compiled by the medical board with input from multiple stakeholders, making sure that that their input was taken. One thing I was going to ask Mr. Palazzolo, I know that we've talked about OBGYN, I would presume possibly MFM and so forth. Now, there are other specialties that do provide care to those who are pregnant, especially, for example, emergency room physicians. Somebody may go to a urgent care center and be pregnant and ask for or have concerns about abdominal pain. So they may not necessarily get referred to an OBGYN right away, and they may be the ones who are initially managing them. Have we specifically set forth who those specialties are and if it may go beyond just an OBGYN physician?
Well, yeah, I think we can. I mean, obviously, the parameters for this were kind of set by the legislature, but just the real world experience is that when we do see complaints or we see reports in the media about this, the emergency medicine profession is really the gateway here. I mean, that's who is seeing these patients first before the OB. And we have seen cases where that specialty has been involved. So obviously it's not in the statute, which is why it's not part of the outreach not part of our official notice that you must take it, but it certainly would be appropriate. And this is available to everybody.
But does the statute specify the specialty, or does it specify those who manage those patients?
So the statute says a physician licensed to practice medicine under the subtitle who provides obstetric care shall complete before initial licensure, and it would also be before their renewal starting January 1st. So
because there are family practitioners, I presume, who may be providing obstetric care in rural areas. There may be, like we said, ED physicians who are encountering obstetric patients in urgent care centers or in the ER. So I'm just wondering, just from the statute itself, it just talks about those who are taking care of obstetric patients. It doesn't necessarily specify a specific specialty. And I just want to make sure that we're, if we're going to do outreach, if that's something that we didn't want to necessarily make it too narrow.
It is something we've discussed a lot. There are some specific specialties that we went through of looking at the specialties that we recognize or the people and it's kind of self-annotate there. So we have critical care medicine, OBGYN, maternal and fetal medicine, obstetrical anesthesia, obstetrics and gynecology, obstetrics and gynecological surgery. So those are the specific ones we put. We did talk about if they need to have family medicine or emergency medicine, but then it was kind of, where do you draw the line? Is it all ER physicians? Is it all family medicine? Again, it's up to how the board would like to do it, but that's kind of what we.
It's just like obstetrical anesthesia, for example. I mean, there's, I'm there is a board for OB anesthesia, but most anesthesiologists, even though they are not boarded in OB anesthesia, do provide care for obstetrics. In fact, almost all of them do. So I guess we just need to kind of figure out, what does that look like so that it's clear what the requirements are.
Absolutely. Again, that's why we wanted to bring it and have you guys kind of talk about it and decide. We didn't want to make it too broad and kind of get people doing it that maybe don't need it, or versus make it too narrow and miss out on those that could benefit from it.
Yeah. Any comments from board members? We're obviously discussing this item. We have to consider it for approval, but I just want to make sure that we had that discussion before we move forward with it. So any other questions or comments by the board members?
Just a quick
I would
question.
make a comment. Go ahead, Sharon.
Yeah, you mentioned several stakeholders. I'm assuming we had several OBGYNs to opine on
Oh, yes. Yes.
the content. Okay.
Yes.
And so this CE has not been published, correct?
Not yet.
Yeah, it can't be published until we approve it.
Right.
Or-
Just
Yeah.
making sure. Thank you.
Yeah.
Dr. Safran, something so simple, really, really dumb, but scenarios is misspelled continuously. So just if anybody can take a look at this.
You can fix that. Yep.
Thank you. I'm starting page 24.
Just a comment I wanted to make. I agree with you, Dr. Safran, when we talk about the family practitioners, the ER physicians. I mean, I don't know if we can think about if you put in, we're not trying to make all of those people, I guess ER would be, but like family practitioners in the rural areas, I don't know if we have to put in maybe something that specifies if you're in this location or if you're involved with these type of patients. Could we kind of pull that subsegment of physicians out? I'm not exactly sure how to word it, but just because in the rural areas.
And it also, and it also has to be in a way that our staff can clearly determine who has to take it, because it is a requirement for the initial or the renewal. And so we want to make sure we comply. So yeah, again, it may be better just to pick the specialties than it may be harder to kind of parse out like locations and those types.
Yeah, I think
it just
one
seems
thing
like
that's
it'll be I mean, I could just see a lot of questions with those type of physicians that like, well, do I need to take this? Am I in this?
So one of the things I think is important for us to consider what the legislative intent of this was. There has always been a lot of concern that that when the law was passed initially, that there was some clarity as to what is allowed and what is not allowed. And I'll give a very specific example is, ectopic pregnancy. If somebody presented into the ER with an ectopic pregnancy, that is a very clear, specific exception in the law. And there was purported confusion because there were some facilities that discharged those patients because it wasn't a ruptured ectopic. And, that led to, permanent harm with those patients. So the idea behind this was to make sure that physicians who take care of these patients are aware of what the rules and the law is as far as managing those patients and not having the unintended consequence of patients that needed to be managed appropriately, not being managed appropriately and having a bad outcome. So the example that I just laid out, it potentially could be an ER that has a physician evaluating a patient with an ectopic pregnancy. They may or may not refer it to an OBGYN. Again, remember that these patients initially, if you're going to come into the ER, they're being evaluated by an ER physician. We want to make sure that they're aware of what those laws are. Again, going back to a family practitioner or even an internist or anybody who may be managing an obstetric patient, the idea, again, is to make sure that they're all aware. So again, there's the specialty itself, but there are also those who are managing obstetric patients. I don't know if you say outside of these specialties, if you are managing obstetric patients up to a certain degree, we would ask it. I don't know that, but if you look at the intent of the legislation, why it was put out there, that's why I think it's important for us to consider what that looks like. Now, we can always just specify certain specialties and then later on try to consider if we need to expand that with a little bit more definition. I just worry about the ER physician part because from my standpoint, they are going to be seeing a pregnant patient at some point coming through the ER. So that to me is maybe not a specialty that is directly involved with obstetric care, but they're always going to see patients who need obstetric care. So that may be one that we may need to consider adding into it. But again, it's open for discussion.
Yeah, and this will be available for everybody. It will take approximately 1 hour is what it's set to do. It is free. So anyone can do it, even if they're not mandated to do it. But again, yeah, it's just as staff, we'll need to know who we're going to require to do it. And if you guys would like to add emergency medicine to it, then that's Scott, you have something?
I just want to be clear, what you're all talking about is who is going to be affected, but what we're asking today as staff is to approve the content for the training. As to who will be involved does not have to be set out in this rule or necessarily done by rule, because we may have to determine that. But today we're just asking for content. We are not asking to attach certain specialties to the content. That's a different element of this. So just be clear. We're asking only for approval of this consensus content today for the educational purposes. The scope of it, as Dr. Zafran and y'all are discussing, is a little bit indeterminate right now. We know where there's a core that will need it, and some of this may be if in doubt, take it kind of thing. But again, we're going to have to learn some of that as we go.
Of course.
Yeah, well, yeah, we are asking for approval of the content of the CME, but it is an important point. Yeah, because staff will need to know who is being flagged to do this.
Yeah, and then I figured it would be an important time to be able to at least get that kind of input. That is, as you alluded to, it's separate from the content being approved, but this is an opportunity for all of us as we're looking at considering approving it to at least, have that conversation. So again, any other questions or comments before I ask for a
I have a
motion?
question. This will be placed for public comment after we approve this?
No. This isn't
No?
a rule. No, this is not
Oh,
a
okay.
rule. This
not
is
a rule.
just
This
the,
is
yeah.
for the, okay. Thank you.
Correct. Yeah, the statute just said we had to come up with the CME and it had to be available and it had to start by January 1st. And so that's,
So if there's some later on improvements that can be made to the training, we can do that, correct?
yes, correct.
Okay, thank you.
Yeah, we can change it as needed. Again, it's not a rule, so it doesn't have to go through the whole rulemaking process. But if there were going to be any substantive changes,
Yeah.
other than fixing, spelling errors or something in there,
Yeah.
thank you for pointing that out. But yeah, we would bring it back to you guys for
Okay,
that
very
approval
good.
for the change.
Thank you.
All right. Any further discussion? Is there a motion on item
Dr.
number?
Zafran, I'll make a
Yes.
motion of item 23, recommendation and possible action regarding SB 31, continuing medical education, Coconuts.
Second Barnes.
So we have a motion. It's been seconded. Is there any further discussion? All those in favor, please say aye.
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 All those opposed? Item passes. I'm going to hold on for a second here.
We may be able to just, with our.
Yeah, checking with my folks, are the consent agendas already? Because we can move to that until we reach the
Licensure
actual
is.
schedule.
Licensure is ready.
DPRC,
Ready.
do we have anything else?
We need finance committee minutes.
Not quite ready on those.
No, there shouldn't be anything for the personnel discussion. So it's really that, and we got 3 minutes before we can start.
Okay, so I'm going to just basically take a 3-minute break.
Pause. Yeah.
And we're going to take a 3-minute pause. We have an agenda item that will come up exactly at 9 a.m. So I'll give everybody an opportunity to take a 3-minute break, and we will reconvene, actually, it looks like in 2 minutes at exactly 9 a.m. All right, folks, we're going to go ahead and start again. Ready to go?
Like recording is still going. Yeah, we confirmed there's nobody else looking to join us in the room today. So yeah, we can proceed.
Okay, agenda item number 13. It is past 9 a.m., so I'll bring this agenda item up. This is consideration and possible action regarding rehearing for Mary Tally Bowden, MD, SOA docket number 503-23-17769.MD. Mr. Carlton?
Yep, thank you. All right, so it has been, I think, quite a while since the board has had a rehearing. So just as a bit of a recap, since this is a little bit different for probably new for most people. So we'll go back a little bit procedurally, how we got here, very briefly, and then we'll turn it over and start. And we'll talk about how this will go. It'll be a little bit reversed from how you guys typically see a PFD. So on October 17th, 2025, the board considered the proposal for decision for Dr. Bowden and the case, the SOA case that Dr. Zafran mentioned. A final order was entered adopting the administrative law judge's findings of fact and conclusions of law and ordering a public reprimand for Dr. Bowden. The final order was authorized under section 164.007A of the Texas Occupations Code. The relevant part states, the board shall dispose of the contested case by issuing a final order based on the administrative law judge's findings of fact and conclusions of law. On November 10th, 2025, Dr. Bowden's attorneys timely filed a request for rehearing in accordance with sections 2001.145 and .146 of the Texas Government Code. So on November 13th, 2025, the board granted Dr. Bowden's request for the rehearing. Therefore, we are here to consider the motion for rehearing for Dr. Bowden related to the SOA docket mentioned before. So each side, board staff and Dr. Bowden and or her attorneys will have a total of 10 minutes each to present their case. Dr. Bowden's attorneys will proceed first and may reserve any time remaining for rebuttal. After the presentations pursuant to section 2001.144 of the Texas Government Code, the board will rule on the motion for rehearing and enter an order disposing of the motion for rehearing, depending on how they rule on that motion. As a reminder, pursuant to section 164.007A1 of the Texas Occupations Code, the board may not change the findings of fact and conclusions of law. So before the board, you do have in your folders all of the relevant information for what happened before and what's before you today for consideration and decision. So with that, is there anything else? No? Okay. Then we will go ahead and start. If we can get the timer up, it's going to be 10 minutes. And so again, Dr. Bowden and her counsel will get to go first, and they will get to reserve any time they have left for rebuttal. And collectively, Dr. Bowden and her attorneys together will have a total of 10 minutes.
Can we confirm that Dr. Bowden's counsel is there?
I do. Okay. Yep. Okay. And I think I do see Dr. Bowden on the screen also. So again, good morning, welcome, and your 10 minutes will begin.
Thank you, Dr. Zafran and the board. Because we were unable to attend the prior hearing, we're generally going to address what we would have addressed in the original hearing on discipline and ask the board to consider that as a basis for rehearing and or taking different action with respect to the final order. What we're asking the board to do ultimately is to find this case does not justify the imposition of any discipline against Dr. Bowden. In support of that, the administrative law judges found only one violation of the Medical Practice Act, relying on Board Rule 190.82P. And the findings of fact cited in the final order, as well as the proposal for decision, do not actually establish that Dr. Bowden violated this rule. And so the board can make its decision based upon the proposal for decision without changing them. Rule 190.82P requires the board to prove that the physician behaved in a disruptive manner and that the allegedly disruptive behavior either interferes with patient care or could be reasonably expected to adversely impact the quality of care rendered to a patient. And the Texas Supreme Court has made it abundantly clear, specifically in the Alleman case, that the board must establish each prong of the alleged misconduct in order to impose discipline. If any prong is not established, discipline is not proper. The proposal for decision does not establish that the board reflected that the board, the proposal for decision does not reflect that the board established any impact on patient care. Findings of fact 34 and 35 are mere recitations of the standard and do not actually qualify as findings of fact under Texas law. Therefore, there is no finding of fact on the second prong of the alleged violation. This matters, like I said, because under element, and this happened because board staff did not present any evidence of these elements at the hearing or on summary judgment. No testimony from the physicians at the hospital, no expert testimony, nothing. There's absolutely no evidence that this second prong was met. And I will just point out, neither the board nor the SOH is allowed to assume the prong was met. There must be evidence. We also dispute that sending a nurse to treat Dr. Bowden's own patient interfered with treatment of a patient. I think it's clear that she had established a physician-patient relationship. And so trying to treat her own patient cannot be interference with treatment with patient care. I'm sorry. Okay. Secondly, I want to address a defect that occurred originally in Dr. Bowden's informal settlement conference. The settlement conference statement of allegations that we received contained exactly 2 allegations: that she had not established a physician-patient relationship and that she posted pictures of Hughley Hospital staff on social media. The privileges issue was not noticed in the summary of allegations. This is fatal to any board discipline that might be attempted to be imposed. Section 164.004 of the Medical Practice Act requires that a physician be given written notice of the issues for which she is going to be supposedly disciplined prior to the ISC and prior to the filing of the complaint. This did not happen, and therefore the board can render only ineffective discipline on the issues raised in ultimately the complaint and the issues ultimately found by the ALJs. And then lastly, and I'm going quickly, but I'm going to respect the time and give the board a chance to ask questions if you choose. The defect in the ISC, it was not simply a technical one. We went to the ISC not expecting the privileges issue to be raised. Because it was not in the summary of allegations, we did not have the court order issued by the Tarrant County District Court in the record. That would have been in the record if the summary of allegations was proper. And I want to read, and that order was litigated to some degree at the SOAH. But I want to read a portion of that order that was ignored by board staff and ignored by the ALJs. And I ask that you please listen to this carefully because I think this is very important. The order said there was the privileges order, and then a couple of paragraphs below, the judge went on to say, Dr. Bowden or her nurse working under her authority is granted access in the ICU at Texas Health Hughley Hospital to patient for the sole purpose of administering ivermectin to patient. Dr. Bowden had an express grant from a Texas State District Court judge to do exactly what she did. Dr. Bowden was not flouting law. She was not pretending. She was not trying to do anything bad to the hospital. She was simply doing what a district court judge told her she could do and what a licensed attorney who was a former judge told her was proper at the time. This case should never have gotten past the ISC. This case was in the ISC mostly. The biggest issue in the ISC at the time was physician-patient relationship. The board dropped that without ever presenting it to the SOAH. That's in the record. Everybody knows that. This has been an unfair case for Dr. Bowden, and after 4 years, the board should put an end to it. Impose no discipline, let the case be dismissed, and let's all move on and stop wasting both the taxpayers and Dr. Bowden's money. And I'll reserve the rest of my time for rebuttal.
Thank you. All right. Board staff.
Hello, Amy Swanholm and Ms. Meredith Massey on behalf of board staff. First of all, the summary of allegations and what happened at the ISC is confidential, but I am going to address it just to clarify and in response to Respondents' Counsel's argument. There were 2 ISCs. One of them related to just the privileges issues that Respondents Council is saying were not covered at an ISC. There were 2 ISCs. One was held on July 27th, 2022. Another one was held on February 24th, 2023. So that was covered. There was an ISC. It was proper notice. In regards to the findings of fact 34 and 35, those are findings that build on and describe what is listed in several other findings of fact. Specifically, finding of fact 33 discusses Dr. Bowden's own statement, which the judges discuss in the language of the proposal for decision in the argument section. They elaborate on that. They explain the basis for finding of fact 33, and then 34 and 35 building on those and explaining that there was a violation. As far as the order from the district court judge, that was also covered in the hearing on the merits. The ALJs found that there was language in there that required, the district court judge required Hughley Hospital to go through the credentialing process with Dr. Bowden. They were in the process of going through the credentialing process when Dr. Bowden sent her nurse to the hospital. That same day, Dr. Bowden, as found by the ALJs, also was informed by Hughley Hospital about 45 minutes before the nurse went to the hospital that she did not yet have privileges. So what Respondents Council is discussing from that district court decision is also part of the whole that the district court judge found. Now, that's not even taking into account the fact that that district court ruling at the time that Dr. Bowden went to the hospital was already moot. So taking that off the table, the district court decision was very clear that she did need to go through the credentialing process, and the judge found, and the facts are indisputable, that she did not have privileges at the time that she sent her nurse to the hospital. Thank you.
Thank you, board staff. Mr. Barnhart, you have 4 minutes and 21 seconds.
So I would simply point out that finding of fact 33 referenced by Ms. Swanholm goes back to the posting of pictures on social media and has nothing to do with sending a nurse to the hospital. And it was the sending the nurse to the hospital that was defined as a disruptive conduct. The disruptive conduct found itself has to be the cause of the interference. You cannot have disruptive conduct A that doesn't cause interference and other conduct cited that does cause interference and somehow combine those two. The statute says, or the regulation says, in a disruptive manner that. And so there's nothing in the findings of fact and conclusions of law that connects the dots and makes Dr. Bowden liable. We're not asking you to change the findings of facts and conclusions law. For whatever reason you do it, we are simply asking the board to find that, to put an end to this and find that under the specific circumstances of this case, including the additional language we quoted from the injunction, that, and including what happened at the ISC, and there was only one ISC, the original one was postponed to the second one, and it was never actually held. What happened at the ISC, that altogether is sufficient that this is an extreme outlier of a case, that Dr. Bowden, under the circumstances in the midst of COVID, with a dying patient, who the court order also says the hospital said was going to die on the hospital's plan or not, but that the hospital was refusing to make any accommodations for their treatment. Under that specific set of circumstances, that the board find that discipline is not warranted in this specific case. We're just asking you to look at the totality of facts, and just say, yeah, we get it, but let's put an end to this. There's no reason for discipline here, and that's that's sort of the end of my point. And I would love to answer any questions if any board members have some.
All right, Dr. Barnhart, Mr. Barnhart, thank you for your comments. I did have one question before we turn over to the board members for theirs. Just as a point of clarification, because this has come up throughout this case, when it comes to the district court order you referenced that said that she would they should go through the credentialing process and that kind of thing. Was that district court order still in effect at the time that the nurse showed up at Hughley Hospital that you referenced, saying that would allow Dr. Bowden to have the nurse go there?
So two-part answer to that question. The strict answer to your question is no. The caveat to that is nobody within Dr. Bowden's team knew that. The email from the clerk to local counsel went into that local counsel spam. Secondly, and I think relevant to this, nobody from the hospital's legal team, even after learning Dr. Bowden was coming, notified anybody from the patient's team that the stay had been put in place. The hospital actually allowed the nurse to come without telling anybody on the patient's team that the stay had been issued.
Okay. Well, thank you for your comments. Again, want to make sure. So you're saying no, it was not in effect anymore, and you said no one from Dr. Bowden's team notified her. Who was Dr. Bowden's attorney that was supposed to notify her at that time?
So the team for the patient was Jerry Ward out of College Station, local counsel. She was the one who received the order and it went into her spam, and she was very clear about that. You also had Pro Hac Vice counsel, Judge Beth Parlato out of New York. Judge Parlato is the one who entered into a attorney-client relationship with Dr. Bowden and gave her advice that it was appropriate at the time for her to go ahead and go to the hospital on the 10th. And that was very clear in the record. And so, I recognize that the ALJ said that there was no attorney-client relationship between Dr. Bowden and Ms. Parlato, but that really is not the case. So, but yes, that is true. There was nobody in that entire team that knew the stay is issued. And I do think it's important that the hospital's team also elected not to inform Ms. Parlato, despite multiple conversations on that day, that the stay had been issued.
Okay, so again, to just make sure. So this is Parlato was the attorney representing Dr. Bowden?
Ms. Parlato did represent Dr. Bowden with respect to whether it was proper for her to go to the hospital at that date and time, yes.
All right, and Mrs. Parlato, she's licensed she has a law license in Texas to give legal advice?
She's licensed in New York. She was admitted in this case Pro Hac Vice.
Okay. I'll turn it over to
I think you had referenced earlier that no impact was made onto the patient. And again, I would just reference the fact that we don't have any discretion to change the ALJ's findings. But I'm reading in finding of fact number 34. It says respondent behaved in a disruptive manner toward Hughley Hospital's personnel that interfered with the hospital's patient care. And in number 35, where it said respondent behaved in a disruptive manner toward Hughley Hospital's personnel that could be reasonably expected to adversely impact the quality of care rendered to a patient. Those are specific findings of fact that is found by the ALJ. The second thing I would just ask is the district court obviously had stayed, their decision was stayed by the appellate court, but was there a conversation prior to that nurse going to the hospital that was a conversation between the hospital and Dr. Bowden as to the fact that she did not have privileges and she needed privileges to come and take care of that patient? Did that happen before the nurse went to the hospital?
I'm gonna refer to the findings of fact on that and say that yes, that is what the ALJs found. I will say in this particular case that it would be a little bit disingenuous for this board to find that a hospital administrator can make a statement that contradicts a state officer, and that whoever that's said to is bound by that statement by a hospital administrator. And as far as your first point goes, the issue on findings of facts 34 and 35, that's exactly my point. Those are not findings of fact. Those are recitations of the element. A finding of fact has to say who, what, where, why, and how. To be a legitimate finding of fact, it has to identify what patients, how, what happened. There's nothing in the record of even whether anybody Dr. Bowden spoke with, or that the nurse spoke with, was actually on duty for patient care at the time. At a minimum, there should have been had to divert this doctor from this unit to speak with her and prevent her from entering. That's not in the record anywhere, and that's not in that finding of fact. That's what makes that finding of fact effective. It is a mere recitation of the element and doesn't recite facts at all.
So first of all, I'm looking at number 33 and 34, which are listed as findings of fact, or 34 and 35, which are listed as findings of fact. But then I also look at 37. Again, these are findings of fact from the ALJ. This is not from the board. That respondent knew she did not have privileges to administer her prescription to patient while in care of Hughley Hospital, but nonetheless intentionally dispatched her nurse to administer the medication, and that respondent's intended result in dispatching her nurse to the hospital was to override the hospital's care plan for patient is a relevant aggravating factor the board may consider in determining the appropriate action. That is a finding of fact from the ALJ. That is not coming from the board itself.
Understood. I mean, obviously, we disagree with that finding of fact, but if you don't get to, but that is aggravating factor. That's not underlying liability. You have to get underlying liability first before you get to aggravating factor. There's an issue here that cart before the horse. Dr. Zafran, I have to say it now. At the last hearing, you said we would discipline any doctor who tried to treat a patient in a hospital where they didn't have privileges. That's actually improper. The statutes do not say it is against the Medical Practice Act to try to treat a patient at a hospital where you don't have privileges. It may violate other provisions of the act and get into unprofessional conduct, but you have to get the elements of that unprofessional conduct that's in the statutes, not the general description of the overall act. The board is limited by what the legislature has said the board can discipline a doctor for.
Thank you, Mr. Barnhart. Let's see, we'll go and see if the board members have any other questions right now.
I have a question for the attorney.
Is that Mr. Crane? There you are. Okay, I see you down there. All right, go ahead.
Councilor Barnhart, why does a hospital have credentialing of a doctor's privileges? Tell us that. Did you not hear me?
As a general,
sorry, Mr. Barnhart,
as a general prop.
Sorry, just one
Right.
second. Your audio kind of broke up there. If you could just start again, make sure we get all of it. Thank you.
Councilor Barnhart, tell us why a hospital won't allow a physician
Actually,
to see.
CMS tells them they have to.
I'm sorry.
Yeah, sorry, Mr. Barnhart, your connection seems to kind of be lagging a little
Because
bit.
CMS tells. Okay, I apologize.
That's
Maybe
okay.
went to the wrong-
For
Let me
a
get it. I got
second,
it.
do you want to maybe turn your camera off for a second? That may help with your bandwidth, because we definitely want to hear your answer to Mr. Crane's question.
That should be better.
Okay.
Is that better?
It is. Yeah, it's working better. So yeah, sorry, just to recap, the question was, why does a hospital have credentialing and a privilege process they go through?
Because CMS tells them they have to.
No, that's not it at all. It's because the hospital's trying to protect the patient and make sure the physician has all the qualifications to care for the patient. So you have a misunderstanding of what the qualifications or what the need for credentialing is.
So we understand that. We also understand that during COVID, the credentialing requirements were vastly reduced.
I bet they weren't.
So, well, the CMS requirements were largely waived.
Well, it didn't make any difference. The hospital still has credentialing protocol, and obviously the Dr. Bowden didn't follow it.
We look, and we understand that is what was held by the ALJs, and we understand the board's point on this issue. What we're saying is, again, it goes back to the very specific facts of this case. With the district court order was issued, with what she knew at the time, and this testimony is in the record, with the doctor who was treating this patient saying this patient is going to die on our protocol. Dr. Bowden, on advice of counsel, sent a nurse to the hospital. There's no evidence that anything happened particularly untoward when the nurse was at the hospital, that there was actually any interference or problems that actually occurred at the hospital. It was a misunderstanding based upon a district court order, not just what Dr. Bowden wanted to do. And that's why we're asking the board to find that that there's no need for discipline in this particular case.
Well, I disagree. Dr. Konos, I'll yield to you. Do you have a question?
Yes, thank you. Could I please ask counsel, Mr. Freshour, to specifically tell this board what is the scope and the limit of our decision process here today?
All right, thank you. The scope and limit of your process today is to rule on the motion for rehearing that was filed by Mr. Barnhart on behalf of Dr. Bowden. Now, you can, if for some reason you want to grant the rehearing based on what Mr. Barnhart has presented today, you would need to consider potentially entering a new order of some type. Could be whatever you wanted it to be. You could follow Mr. Barnhart's urging, and I believe, and I don't want to misquote you, Mr. Barnhart, but it would be accept the findings of fact and conclusion of law, but determine that no discipline of any kind was warranted. I believe is what your relief was in your prayer, or something to that effect. You
That's
could do that. Okay, good. Didn't want to misquote you. Or you could do that, where on the other side, what you could do is you could deny the motion for rehearing today, and you could just have the order that you entered previously to stand. Now, what that does is that would create the ability for Mr. Barnhart, on behalf of Dr. Bowden, to proceed with an appeal to the state district court, because Mr. Barnhart, as an experienced practitioner, knew that in order to potentially have to appeal this, if that's what he and his client decide, they have to file a motion for rehearing with the board. So if you deny it today, and it's, again, as I said, let the order stand that you previously entered, then Mr. Barnhart and Dr. Bowden could file a suit for review in state district court. And that would be along the lines that I talked about earlier in my litigation report today. It would be called what we call substantial evidence review. And that would be filed here in Travis County State District Court. Does that help, Dr. Quinones?
Yes, it does, sir. Thank you very much. I would like to make a motion when ready.
So, Dr. Quinones, the only point I would make is the reason we approached this and took the approach we did today is because, for whatever reason, I was not able to appear at the original hearing. And so we're simply trying to make the arguments we would have made at the original hearing. So we understand and appreciate your asking to narrow down what's at issue here today.
Let's see, does the board have any additional questions before we get to any motions?
Yeah, I have a clarifying question. There was a mention of there being two ISCs. And Mr. Barnhart, you came back and said, well, the first ISC was canceled. Is that correct?
That is correct. The first ISC was scheduled, and then we received notice that it was being rescheduled, and they actually combined the ISC for Hughley Hospital with another one, and both were held together. And the investigation wasn't completed on the other matter at the time. And so both were held on February 24th, but it was from two different complaints that turned out to be unrelated.
Okay, so the two complaints were combined in the second ISC?
Yes.
Okay, gotcha. Thank you.
So again, Dr. Barnhart, I keep saying that, sorry, Mr. Barnhart, so many doctors in the call today. Mr. Barnhart, so you're saying that at an ISC, the privilege issue was raised and discussed.
It was not. So I need to be very, very clear, because I want to be fair to the board members. The issue of privileges was not noticed for any ISC, right? And 164.004 requires notice prior to for the opportunity to show compliance. The issue of privileges was discussed at the ISC, but it served, it wasn't anybody's intention, but it served as an ambush at that point because the notice was not provided by board staff.
Okay, well, if we can have a second and check that, we'll have board staff.
Yeah, I'd like to know what exactly was, just so that I'm clear too.
While board staff is checking that, Dr. Quinones, your hand is still up. Is there something else you wanted to, or is that?
No, I was going to ask board staff to look into both those ISCs, because If I'm not mistaken, I think I was at both ISCs.
Dr. Quinones has been at 2 ISCs for Dr. Bowden, but it actually was for 3 different matters, 2 of which involved ivermectin.
Okay, we'll see what Ms. Swanholm.
Okay, another question. You said involved ivermectin, but that the ivermectin ended up not being the focus of the ISC. Is that correct?
Generally, that's what happens, correct. Dr. Quinones is actually very good about discussing issues such as informed consent, you know, and then effectively the rules around alternative medicine.
Right.
Okay. And so
now I will say this complaint originally the complaint that was filed, if I recall correctly, did originally raise ivermectin issues because it alleged Dr. Bowden prescribed a drug for non-therapeutic purposes. That's inherently raising ivermectin in the complaint,
But
whether
the board,
it says the word ivermectin or not.
But the board did not take that issue as something that was relevant because we all know as a board, and I think we've had this conversation, that anyone is free to give whatever medication they want, including ivermectin, of course, so long as there's proper informed consent. But that was made clear, regardless of what the initial complaint was. But I'd like to hear from board staff.
So, Dr.
regarding
Zafran,
the
I'm
ISC.
not talking about the complaint to the board. I'm talking about the complaint filed at the SOAH.
Board staff, if you can clarify or give some more information on the ISC notice.
Absolutely. So there were 2 ISCs. The original one was noticed initially for July of 2027, 2022. There was notice sent to Mr. Barnhart as the attorney of record, notifying him that it was being postponed, and then it was rescheduled at the same time as the second ISC on February 24th, 2023. Board staff sent out the ISC packet pursuant to that initial notice and then notified them that the date of the ISC was being rescheduled. February 24th, 2023, both matters were heard. The notice was separate, obviously, because there were separate investigations and separate legal cases associated with each investigation. And then both of those legal cases were heard by the panel at the same time. Now, the discussion at the ISC is obviously confidential, so I cannot, discuss what was talked about or what was argued. But as far as the notice documents that were sent out and the backup information in the ISC packet, including 2 separate SOAs, the first SOA did cover the privileges question and the issues alleged related to privileges that were then pled at the State Office of Administrative Hearings when a settlement agreement was not able to be reached on both cases. I can also address the ivermectin question related to the SOA complaint if you'd like to hear information about that.
I would.
Okay.
Please, thank you.
So we did not allege that the fact that ivermectin was prescribed was a violation, but initially alleged that there had not been a physician-patient relationship established that would allow for any prescribing of any drug to that patient. After board staff won their motion for summary disposition, the complaint was amended to narrow the scope of the hearing so that we could move forward solely based on aggravating and mitigating factors. So it was a decision in order to move forward with the case and to move to the next stage in the case.
Is there any additional questions by board member? Go ahead, Amy.
If I could just address some of the statements of a factual nature made by Mr. Barnhart. Many of them do not represent evidence that was submitted in the hearing on the merits, nor are they consistent with the findings of fact made by the Honorable ALJs, which this board does not have the authority to change. We are bound to accept and adopt the findings of fact and conclusions of law that were issued by the Honorable ALJs. Sorry, my computer just closed up again. Give me 1 second to open it up. So one example, Ms. Parlato was not admitted to practice in Texas Pro Hoc Vice, and she actually testified herself at the hearing on the merits that she did not have Pro Hoc status. Instead, it was another attorney, Ralph Larigo, who was admitted and who was sponsored by the Texas attorney that Mr. Barnhart mentioned. So just clarifying that, it's on page 158 of the transcript if anyone would like to look it up. Thank you.
Thank you. Any other questions by any of the board members? Dr. Quinones, you said you had mentioned that you wanted to make a motion.
Yes, I'd like to make a motion. Based on the scope and the limits of today's discussion as outlined by General Counsel, I would move that we reject the request for a rehearing of this case.
A motion's been made by Dr. Quinones. If I could make an amendment also to the order, to the motion. Manny, if it's okay with you, I would also like to, if you're proposing that, then I would also add that I further move that the final order entered on October 17th, 2025 regarding Dr. Bowden stands and is final pursuant to section 2001.144A2A of the Texas Government Code.
Thank you. I accept that amendment on my motion.
And I would second his motion, Dr. Farmer.
Motion's been made by Dr.
The motion with the amendment.
The amendment. Dr. Farmer, you're
Yes,
seconding
with the
the motion with the
amendment.
amendment? Okay,
Yes.
thank you. So motion's been made by Dr. Quinones. It's been seconded by Dr. Farmer with the amendment. Is there any discussion by board members on the motion with the amendment? Seeing none, all those in favor of the motion with the amendment, please say aye.
Aye.
All those opposed? All right, the motion with the amendment passes. All right, this matter, the PFD is finally closed. Brent, you want to make any?
Yes, on this agenda item, Dr. Bowden and Mr. Barnhart, thank you for being here.
And thank you, board, for taking the time to let us have our day in court, so to speak.
So,
Thank you so much. All right, the next item is agenda number 14, which is another PFD, consideration and approval of proposal for decision. Maria Dolores Chapa, MD, SOA docket number 503-24-12946.MD. Mr. Carlton?
yes, so kind of back to the standard format that you're aware of with the PFD in consideration. So in this case, the board staff will go first. They'll have their 10 minutes, and then respondent will go second with their counsel, and board staff has the right to reserve any time they may have remaining. And so with that, we'll go ahead and proceed. Is that Mr. Nelder that's going to be presenting board staff? You may go ahead.
Yes, sir. Can you hear me all right?
Yes, we can.
All right. If I may begin. Good morning, Mr. Carlton, Dr. Zaffron, and board members. Shane Neldner on behalf of the Litigation Division. I'd like to reserve whatever time I have left following this presentation for rebuttal. I'm here to present the final order in the matter of the complaint against Maria Chapa, MD. Just a reminder, as we heard before, we are limited to the ALJ's findings of fact and conclusions of law, not to relitigate that proceeding that was already litigated thoroughly at SOA. We are only here to determine the ordering provisions of the final order. Now, this case involves respondent's treatment of one patient. And the following are ALJ's findings of fact. They are not mine. They are not board staff's. They're not what we want. They're what we have. Respondent's care began in April 2015. Patient had previously been diagnosed with incontinentia pigmentosa, an incurable ectodermal dysplastic syndrome that affects the muscles. Patient had also been hospitalized twice for cerebrovascular accidents and strokes. On the very first visit, respondent diagnosed patient with backache, pure hypocholesterolemia, insomnia, and headache. Respondent noted that patient had been taking hydrocodone for pain but had run out. Respondent immediately prescribed Norco, Ambien, and Fioricet. Respondent took no adequate medical history. Respondent obtained no medical records of prior treatments. Respondent engaged in no problem-focused physical examination specific to the chief presenting complaint. Respondent's treatment plan lacked a specific cause of patient's pain or any plan to narrow down the potential cause of that pain. Didn't have a plan to order testing or imaging. Didn't have a plan for other treatments to be considered. No plan for periodic reviews. No objectives to determine treatment success. Respondent continued to treat the patient in this manner for 7 years with minimal variation until patient's death on July 17th, 2022. Now, we're not saying that this care caused the death, but the patient was the patient of the respondent for the rest of her life. Included in that continued care, respondent continued to concurrently prescribe controlled substances, including opioids, barbiturates, and benzodiazepines. No treatment plan for chronic pain, no ruling out alternative diagnoses for reaching a more definitive diagnosis, no attempt to use alternative therapies, no attempt to switch to more conservative drugs, no periodic review and adjustment of such reviews of the plan, no educating the patient on the risks and benefits of using controlled substances, particularly in combinations such as hydrocodone and benzodiazepines and or barbiturates, no obtaining of the patient's informed consent to the medication regimen, and no opioid contract with the patient until well after the board made such a contract mandatory. Now, between 2015 and 2018, patient visited the ER at least 4 times for complaints of pain that were not managed by the controlled substances prescribed by respondent. Respondent did not adjust the treatment plan in response. Over the course of 7 years, respondent ordered 11 drug screens. Only 6 test results are included in the patient's medical records. 3 times the patient tested negative for the drugs that respondent was prescribing, including Norco, Fioricet, Restoril, and Valium. This was never addressed anywhere, and the treatment plan never changed. The patient had other known factors for risk for addiction or abuse, including a history of heavy smoking, ER admission for overuse of Fioricet with a family member who reported concerns that the patient might be taking too much Fioricet, a diagnosis of major depressive disorder, and repeated requests for addictive medications such as Xanax, Restoril, and phenobarbital. Again, no change to the treatment plan. Respondent never adequately reviewed the patient's treatment plan for progress or lack of progress. Respondent did not refer to the patient to a pain management specialist until 7 years into heavy chronic pain prescribing. Respondent referred the patient for evaluations by experts eventually in neurology and orthopedics and for necessary diagnostic testing, but the patient did not comply with those referrals. And other than citing to financial hardship, the respondent didn't record why. The respondent also never adjusted the treatment plan or discussed with the patient the implications for continued treatment in light of the patient's inability or unwillingness to seek specialized care. And it should be noted that the patient did follow up on other referrals for specialists in gynecology, ophthalmology, and cardiology as referred by respondent. And respondent failed to document PMP checks on multiple occasions after July 13th, 2020. Now, conclusions of law. The ALJ found that the respondent may be sanctioned because respondent failed to meet the board's minimum standards in her care of patient in initial evaluation, including medical history and physical examination, development of a treatment plan, discussing risks and benefits of controlled substances, obtaining informed consent, entering into a written opioid contract with patient, conducting periodic reviews, obtaining consultations, and the ALJ cited to 164.051A3 and Board Rule 170.3, 1 through 6. The ALJ also found that the respondent failed to meet the minimum standards for documenting treatment of chronic pain, including diagnostic, therapeutic, laboratory results, as well as consultations with physicians who treated the patient, and that was citing to the Act 164.051A3 and Texas Administrative Code 170.7. And respondent failed to check the PMP, and that those citations to the law. The ALJ found no aggravating or mitigating factors. Now, as far as board history, the respondent has one non-disciplinary remedial plan in 2020. And so because of all these things that we've considered, we looked at the ordering provisions that would be appropriate and the attached graphic at Board Rule 180.5, 190.5 in the old rules. We have recommended a public reprimand, no controlled substances, no treatment of chronic pain, the JP exam to ensure that respondent knows what the law requires when practicing medicine, PACE prescribing, 16 hours of CME, more education so that she knows what she's doing in the future. That includes 8 hours in medical record keeping, which was a continuous problem throughout and 8 hours in drug-seeking behavior. And because this is a restriction, no supervision of physician's assistants or APRNs, and no delegation of prescriptive authority. Again, all of this is within the sanction guidelines, and board staff would ask the the board to enter the final order submitted for your consideration. Thank you.
All right, thank you. We have, is it Mr. Anderson?
That's correct, Your Honor. Sorry, force of habit. Apologize.
That's okay.
A little bit of background. This was brought originally on a complaint after the death of this patient by a family member in the belief that there had been some type of drug problem. As it turned out, that was never developed. It was, and there was actually an allegation that my client had literally lied to the medical examiner and withheld evidence from the medical examiner. My client refused to accept anything like that in terms of findings. She does not believe that she was ever dishonest in her care, nor does she believe that drugs played any role in this lady's death. And there was documented evidence of that, and there are no findings to that effect. The findings were that there is simply no evidence to support any of those allegations. With regard to my client's record keeping, and again, her feeling had always been that for a solo practice physician, particularly during COVID, but also previous to that, she had a chronic pain patient with very limited resources. For the years that her drug records are available, and she always filled her prescriptions at the same place. For those years they are available, they showed that she filled all of her prescriptions on time and never doubled up, never requested additional prescriptions, never sought additional drugs. The drugs were given for known conditions that had been diagnosed by specialists in the field. My client first saw her in the hospital on reference from another physician. So her feeling was at the end of the first ISC was that she had just not had the opportunity to be heard and to explain what she had done and why. So we filed, or we refused to agree to the settlement agreement. We had a SOA hearing. She has had the opportunity to completely explain the findings are what the findings are. I think the administrative law judges did an excellent job of sorting through the evidence, trying to do their very best to be fair to my client. There are a couple of minor factual issues that none of which affect the outcome of the case, but we wanted the board to understand how we got here, that this is, this is a lady practicing in a solo practice environment, dealing with a chronic pain patient with multiple problems and very, very limited resources. We do not dispute the findings and the legal conclusions of the ALJs, and believe that adoption of the ALJ proposal for decision would be appropriate in this case.
All right, sir. Does that conclude your comments?
That concludes my comments. Thank you.
Okay, thank you. All right. Mr. Neldner, you've got 2 minutes and 52 seconds if you'd like to use it. You're muted.
Thank you, and I apologize. Board staff would only say that we believe that the PFD, the proposal for decision, is our guiding principle here, and where we're relying upon, and that they justify the ordering provisions that board staff seeks in this case, and would ask the board to adopt it as submitted. Thank you.
All right, thank you. One question for Mr. Anderson. So you're saying you think it's appropriate to adopt the PFD, which is what the board is supposed to do today. What is your, I guess, proposal for an outcome?
Well, we would like to reserve for the doctor the chance to again have prescribing authority when she completes the educational process. she would like to be able to continue treating her patients, understanding that there are record-keeping issues that are going to need to be addressed.
Sorry, I'm just making a note for you here. Go ahead, Dr. Snyder.
So I'm presuming, again, we've done this for a while, but if the proposal as for an order is passed, there would be the ability for her to come back afterwards to petition for getting back her DA license, her ability to prescribe and so forth. Is that correct?
For modification or termination if the terms are.
Yeah, we use our standard language, which allows modification and or termination after 1 year. I know, Mr. Anderson, you've been doing this a long time. You're familiar with that modification provision, and that does appear in the final orders where appropriate. And I believe that's what you're asking, Dr. Zafran.
Yes, just want to make sure that it's not different from what we're used to. So that assuming that we're going by what is proposed, that would give you that benefit or your client that benefit.
With that, we have no objection to the board adopting the proposal for decision.
Thank you. Is that it?
Well, yeah. I mean, are there any other questions from other board members? I don't see. Sorry, we can't see everybody online. Your client is not on today, or is?
I believe she is. She may be somewhere down the road. She was trying to get on just a few minutes ago.
There we go. We see her. All right, ma'am. Thank you for joining us. So anyway, board members, if you have any questions for board staff or Mr. Anderson or Dr. Chapa.
I'd like to make a motion.
Okay, we have a motion. Go ahead.
I'd like to make a motion that we accept the proposal for a decision on Dolores Chapa as outlined in agenda item number. I'm sorry. 14. Yes.
Okay, so in there is a proposed order. I am presuming, Dr. Bhakti, that's what you're referencing, right?
Yes, I am.
Okay.
Notice final order, proposal order, yeah.
Okay.
Yeah, so the motion would be to accept the proposal for decision, the findings of fact and conclusions of law and the board order as presented by staff.
Yes, that's correct.
Yeah. Okay. Is there a second?
Second, Barnes.
Second by Ms. Barnes. Is there further discussion on this motion? Seeing none, all those in favor, please say aye.
Aye.
All those opposed? All right, agenda item number 14 passes. Thank you very much.
Thank you.
All right, next item is number 24, which is discussion, recommendation, and possible action regarding, discussion, recommendation, possible action regarding proposed rule amendments to 22 TAC, Chapter 173, Office-Based Anesthesia Services, Subchapter B, concerning IV ketamine therapy standards, 173.6 to 173.14. You have that proposed rule in your docket, in your packet, under agenda item number 24 as a proposed rule. Would you guys like to highlight the rule and any comments that we might have had before we open it up for discussion?
I would, Dr. Zafran, just jump in to point out, and you've been very good about this today. This is a consensus rule. There were stakeholder meetings on this. We had several stakeholder meetings. Then I believe two of the stakeholder groups being some of the ketamine providers and particularly the Texas Anesthesia Society of Anesthesiologists met to work through this. And so we've got a consensus document today. And the focus of the rule and the consensus group was to get the clinic certified, but also to set safety standards and to provide safety equipment for the use of the ketamine as described in these rules. And that's really where we are at this point. And that's all I wanted to say from board staff standpoint. We would certainly recommend adopt it. This would be for publication and comment. It would be up for comment for at least a minimum of 30 days. Depending on those comments, we could bring it back to you potentially. Our next board meeting is March, I believe. Yep. It could come back at that time. So that's the status of that, Dr. Zafran.
Thank you. Yeah, just kind of going to the 30,000-foot level as to why this rule is being proposed. We haven't had in the past, other than some previous rules, a lot of clarity around what the requirements are in ketamine clinics, and as they have been becoming more and more prevalent, it's around the country. A lot of different boards have been grappling with making sure that patient safety is of high consideration as these clinics become more and more prevalent. Just to kind of briefly mention, ketamine is an anesthetic agent, and the FDA classifies it as an anesthetic agent. There was a lot of conversation and discussion about a term utilized that was sub-anesthetic doses, and I think there was a lot of conversation around the fact that there is no definition of a sub-anesthetic dose. It really is all patient dependent. A very small dose of an anesthetic can have a very large impact on a patient, especially if they are on other medications also that can kind of compound that. Whereas with other patients, a larger dose may have a minimal effect. So really the most important thing with a medication and a drug like this is the monitoring, making sure that the impact of it on its sedative properties, slowing down respiration, making a patient more obtunded and so forth, that the ability to rescue that patient from that airway compromise is something that the training and the ability and the equipment at where this location is something that would be available. So a lot of the proposed language in the rules is centered around that. There is discussion around the availability of the physician that is prescribing the ketamine. And also there was some conversation preliminarily about the different forms that ketamine is administered. Ketamine can be administered in an intravenous format. It can be administered intramuscularly. It can be administered intranasally. It can also be administered orally. A lot of the oral and intranasal ketamine is actually something that is done at home. These prescriptions can be made, and there could be situations where the medications are sent to these houses and so forth. We didn't address that specifically in this specific rule. This is specifically around intravenous ketamine, but I would point out that there are potential for harm even in those scenarios at home, even though we haven't addressed it specifically here. I think there have been some cases that have been outlined where a patient may have been on other medications, especially if these are chronic pain patients, or even if they're psychiatric patients where they're utilizing ketamine for PTSD or utilizing ketamine for chronic pain. A lot of these other medications have sedative properties also. And if you add those medications to ketamine, you can have a profound respiratory depressive effect. So even though we haven't specifically tackled non-intravenous ketamine, at some point it may be something that when there's a lot more data on it, that we may need to visit also. But from the clinic standpoint, making sure that the appropriate equipment, the appropriate training to rescue an airway is appropriately done. Now, I know that a lot of reference was made to ACLS training. I would like to just make sure that I emphasize that ACLS is advanced cardiac life support training, is something that you do when a patient actually goes into cardiac arrest. The idea of airway management is to manage that patient's airway prior to actually going into cardiac arrest. You want to make sure that you're able to manage something that you can easily manage prior to actually getting to a sentinel event like going into cardiac arrest. Managing an airway is a very different type of skill set that I think part of the rule talks about making sure that there's adequate airway training to be able to, number one, recognize that an airway may be compromised, and also recognize how to rescue that airway, which there's a variety of ways to be able to do that. The monitoring, of course, of airways that may be compromised is also something that a lot of discussion between the stakeholders was had with this. I would just like to emphasize again that looking at O2 saturation by itself is not a good, adequate way to look at respiratory compromise. A patient who is breathing well has quite a bit of oxygen reserve, and they can stop breathing for several minutes before their oxygen levels actually go down significantly. So by the time that oxygen levels goes down to a point where you feel that there's a need to rescue, it may already be quite late. And I'm getting into a little bit of specific medical details here, so forgive me, but basically when you stop breathing, you may be oxygenating still, but your carbon dioxide levels, which you typically breathe out when you're breathing, can accumulate and become at a much higher level in your body. And that can cause other effects like acidosis, which can also have an impact on the patient's blood pressure, their hemodynamic status, and can also lead to cardiac arrest. So utilizing something like an end-tidal CO2 monitor, which is a way to actually recognize that a patient has stopped breathing before their oxygen levels has gone down, is something that was specifically mentioned as important airway rescue, well, not rescue, but monitoring type of equipment in this type of setting. So again, I'm just kind of highlighting some of the main things that are in there that was put in for consideration before I open it up for specific comment. I think there's a couple of hands that are raised. I think number one is Dr. Jones. The floor is yours.
Thank you, Dr. Zafran. Apologies, my voice is a little bit hoarse. So I really agree with what you were saying, how fast things can happen and how it can go unnoticed through no fault of the clinician in the room based on the monitoring equipment they have available with the oxygen level in, an otherwise fairly healthy person can maintain that for a while. And so just based on the acuity of how quickly things can happen with an anesthetic agent, there was one portion of this chapter 173 that I was looking for a little more clarity on, and I'd love to have a discussion on it. But 173.8, and then that's letter F. And so that surrounds the personnel available for the patient. And so it mentions that whoever the clinician is in the room with the patient obviously must be available for that patient. But for the delegating physician, I just want to make sure that we're very clear on this, because it says the delegating physician must be available, it must be immediately available for consultation and emergency management throughout the ketamine administration. I want to make sure that we have clarity on whether or not that means in the facility versus by phone, because I think that some more enterprising folks might think that that's by phone. And when you're dealing with a substance that can cause respiratory depression, I think we have to be very careful, especially when, it's still an off-label use. And the only on-label use with nasal ketamine, as you mentioned, carries a black box warning for respiratory depression. And so I think we should seek greater clarity in that statement regarding where that physician is, because in my opinion, being immediately available for emergency management, that means being on premise, not necessarily right at bedside, but on premise. And so I think we need to add clarity for that.
Thank you, Dr. Jones. I know it says, it says immediately available, and it says must be immediately available. I understand what you're saying, and I guess if the word for consultation wasn't there and it said must be immediately available and, immediately available for emergency management throughout the PKT administration, would that be a little bit less ambiguous, or are you looking for something more than that? Or are you suggesting something more than that?
Yeah, are you suggesting it say on premises?
Must be present.
Or as Dr. Vanderwide said, just change it. Is the idea it would be present just like it says for the APRN, PA, and RN?
I think that there should be some latitude. I don't think there need to be 2 ACLS certified clinicians at bedside for this. I do understand that this might be in a facility that has other things going on, and I'm not trying to be overly burdensome, but I do think there needs to be some clarity. I think something to the effect of on premises, but not necessarily in the room, should be additional clarity.
So what you're suggesting is must be immediately available and again, this is just a conversation right now. We're not making any motions or making any suggestions, I mean. And the delegating physician must be immediately available on premises for consultation and emergency management throughout the PKT administration. Is that what you're suggesting?
Yes.
Okay. Any
Dr.
other?
Naidoo?
Dr. Naidoo, hold on one second. Let me just go to Dr. Green, and then I'll go to you.
Thank you.
Thank you. I had the same concern as Dr. Jones. I think you may have to be even more explicit in your language and say physically present, something very, very specific, because people may try to do it on FaceTime and things like that. And that's when you have a patient that has an airway emergency, you can't phone it in, you can't do it virtually. That just does not work and patients could die. So that's very concerning to me.
So Dr. Green, if one said immediately available on premises, that presumably means that you can't be in a different location on telehealth. Would that still be sufficient from your standpoint?
Maybe so. I do think about all the ways people could potentially, unfortunately, try to get around that on premises.
Yeah, I would just caution that, again, this is a stakeholder consensus document. We got to be careful about making too many substantive changes.
Right.
So I would just suggest that we limit and again, it's just a suggestion from me. You can do whatever you want, but I would just be cautious about trying to keep the changes. I'm just on premises, I think, is a small change, but if we go beyond that, we typically have to have this vetted and approved prior to actually even going out for deliberation. So, I just want to put that caution out there.
And let me kind of jump in and echo what Dr. Zafran said. This is a consensus statement, and the consensus came from and included the Texas Society of Anesthesiologists. And again, in many instances where we have people trained, particularly the APRNs and the PAs, and in this case, it was insisted by the groups that all of those individuals be trained in airway management. We typically use the phraseology of, and we made it very clear here by using the must, immediately available. We've used that commonly in a lot of situations related to delegation with the assurance of proper training. And this has more training in it than a standard APRN PA type of delegation relationship. So again, that needs to be looked at.
All right, thank you. I think next was Dr. Tibbles and then Dr. Naidoo.
Yeah, I'm sorry if this was addressed in the role. I'm struggling with my Laserfish to go look for myself. So I guess kind of a two-part thing. Was there any discussion among the stakeholders about a carve out for end of life or hospice patients? I say that because things like intranasal ketamine are today pretty standard use at end of life. So curious if there was a discussion. Entities like NCCN and others talk about its utility for intractable pain and terminal depression and those kinds of things. Was there a discussion, and is there an opportunity? That feels like a substantive change if we were going to make that.
It's not necessarily a substantive change because you're actually reducing the restriction, and Mr. Peshaw's counsel can correct me on that if I'm wrong.
Yeah, I don't think it would, because you're still affecting the same theoretically regulated community, and you're actually taking out a portion of them that they're using this drug. But again, we could look at that. But again, if you also look at, and we spent a long time, Dr. Zafran really worked a lot on this, is what the definition of this therapy is. And it's related to conditions, such as PTSD, drug-resistant depression, those kind of things. So the definition of the use also helps keep that universe. But that is a good point, Dr. Tibbles. But again,
I would strongly advocate, and we'll love to hear a discussion on, and I'm going to tell you why I'm being specific, on a specific carve out for hospice. I could make the case for a broader term like end of life or palliative, but I think that those terms allow some workarounds to say, well, I'm doing this for palliative reasons, could cause some problems. So I would advocate just for a very narrow, specific carve out for patients on a hospice benefit.
Okay. That's something we can discuss either adding on here, or we could take it as advisement from during the comment period. And if we're being advised that it wouldn't be a substantive change, it would be something that could be added, presuming it would come back, or we could try to add it now. I mean, either way, you know,
I guess I'm proposing we add it now, and that doesn't mean we have to. I'm one person, but would love to hear others' feedback if
okay,
there's some.
we can do that.
Yeah, we can craft some language on that, Dr. Tibbles. And this is going to be published out so the stakeholders can comment on it. And what I would do to ensure that is we will make sure that notice goes to all of our stakeholders that agree to the consensus statement in particular, but all of them stating, hey, we're publishing it for comment, but please note this portion has been added and look for comments on it.
Got it. Thank you.
All right, thank you. And I believe next is Dr. Naidoo. Actually, well, let me go to Dr. Naidoo and then Dr. Vanderwide after that.
Yes, sir. When you do the ketamine as an outpatient, they should have an ambulatory setting like ICU. They should be monitored, observed 2 hours after the ketamine because most of the effects can come afterwards. Blood pressure instability, cardiac arrhythmias. I think they should be monitored and observed 2 hours afterwards and have some antidotes for excessive salivation, like physostigmine or whatever, atropine and things like that. There is a particular setup when they give ketamine. And it's like an ambulatory CCU type of setup if you give IV. Small doses may be all right, but we are not restricting the dose. If you give higher doses, you need to have type of ambulatory CCU setting with monitoring and observation and some drugs too for the side effects. And some people get confused and very much agitated and have to have something done with it. That's just my point, how the ketamine should be given.
Yeah. So thank you for the. Sorry, I didn't mean to cut you off. Are you done? I'm sorry.
That's
I was just gonna.
In our hospital.
Yeah, so I was just gonna say that again, this is why stakeholders that are very much involved in utilizing some medication were involved, and this is why we're talking specifically about a setting like an OBA setting where there are monitoring equipment, airway equipment, the people involved having specific airway training. All that is it's not an ICU, but it's not just a regular office with nothing there. So that there's a lot of nuances in this that are built in to make sure that it's an environment that is safe for the patient, especially with a drug that is potentially harmful if a patient reacts to it in a certain way. Dr. Vanderwide?
Yeah, this is quick. I just wanted to confirm that the CRNA falls under APRN.
Yes, it does.
Thank you.
So we have some stakeholders on. Let me just go ahead and finish with the board members first, and I will circle back to our stakeholders. So I'll go to Ms. Troncoso. You can keep your hand up, Dr. Prashad. I'll get to you. So Ms. Troncoso?
Sure, thank you. So you started the conversation about the fact that we are aware that there are different practices where people are receiving at-home treatment. And I know that the language is what I read in the draft proposed rule said there's no opportunity for that. Like it's not allowed to be mailed or people treated in their homes. And I'm sure many of us received a letter from a physician that was kind of advocating for rules related to the treatment of how it should be managed for at-home use. And I've heard all of the anesthesiologists and physicians in the room talk about how you need to be very prepared for that. And yet I know that there are probably clinics nationwide that are doing these online treatments where they interview the patient and then say, okay, I'm signing you up for the program. And they do the mail order ketamine, and maybe they're monitoring them remotely or through a camera, FaceTime, et cetera, and attempt to manage the patient if they do while they're in their home, but they're miles away. how do we effectively manage that? Or are we proposing a separate rule at a later date that might address at-home treatment?
So this is specifically related to IV ketamine. There have been suggestions, I don't think it's been entered here, but there have been suggestions that we look at, for example, at a minimum, adding ketamine to the requirements for PMDP monitoring. I don't think that's in here, right? Is it?
We do have PMP monitoring in here, but again, to your point, Ms. Troncoso, as Dr. Zafran was saying, our definition and what this rule is focusing on is the IV, subcutaneous, and intermuscular IV therapies that are being provided right now. It is not for the at-home problem. And I think, Dr. Zafran, we had a case or an issue at the last board meeting where they were mailing the ketamine in a different form, but it wasn't this form. This is a very particular form that we're dealing with here from that standpoint. But again, if it becomes an issue, certainly rules, but this rule is much more focused.
This is very focused on this. The PMDP, I think, is a little bit wider that we have in here. I'm presuming that there may be some proposals for other rules regarding the others. I mean, as Dr. Jones alluded to, there is now an FDA black box warning specifically to intranasal ketamine. So that may require some additional regulatory rules around that. But right now, this is just specifically focused on the specific formats of how this ketamine is being administered. This type of ketamine, the way it's being administered, is not the type that could be sent to a home intranasally or orally. Not to say that that shouldn't be regulated at some point, but this is what this is focused on right now.
Thank you, sir.
Thanks. All right, any other board members? Okay, so I understand that there are some stakeholders that are here. I typically don't give that opportunity, but I will, since they were involved actually in the conversation and consensus beforehand. So I believe Dr. Prashad, you're on. Go ahead.
Hi, thank you just so much, Dr. Zafran. I really appreciate the opportunity to have been a part of this process. And this is very groundbreaking what you guys are all working on and trying to do. And I think it's really going to set the stage nationally. So I'm just grateful for all the groups that have been involved. But I just wanted to let you guys know that I am here. So if there are any direct questions, I'm happy to answer them. With regards to the on-site definition, I think people do want to be able to have very clear rules. So I think as much clarity as you can give for that, so there isn't any kind of ambiguity, I think that's probably best, so that the intentions are very, very clear. And then just with regards to what Dr. Tibbles was talking about, so my understanding is this is not addressing nasal, right, at all. So I know you had mentioned nasal. And then I just wanted to also remind everyone that there are online companies that are mailing ketamine for subcutaneous use directly to patients at home. And that the people are able to hoard those doses and administer them to themselves intramuscularly. There is an ongoing case right now for a patient that died in another state from oral at-home use. So that's just another thing I wanted to make everyone aware of. But I'm also just here if anybody has any direct questions about the stakeholder process.
Thank you, Dr. Prashad. And before I make a comment on that, is somebody from TSA on that would like to comment? Texas Society of Anesthesiologists? Okay. Let me just emphasize, this was a really strong collaborative effort between APSK and, ASPK, American Society of Physicians for Ketamine. I think is that the right acronym? ASKP? Yeah, I think so. Sorry, you can correct me if I'm wrong.
It's ASKP, yes.
ASKP, American Society of Ketamine Physicians. I think that's the way the acronym is. And the Texas Society of Anesthesiologists. And a lot of the consensus around this was something that both agreed to. And those who review our proposed rules took that into consideration. And that's why when we talk about making any changes, we're very cautious in making any changes. But if I'm seeing that both key stakeholders, I'm presuming TSA, unless they say otherwise, are in agreement in clarifying language on presence on site, I think that makes it a lot easier for us to go ahead and add that language in there as it goes out still for public comment, and along with the language that Dr. Tibbles is proposing as far as having a carve out for for hospice or end-of-life care. So thank you very, very much for being involved in this process. Makes this whole thing much more seamless and make sure that we are not missing anything because of the valuable input that you provide. Any other comments? Dr. Prashad, I'm sorry, is your hand still up or?
I was just going to say very quickly that the exact language about the on-site right now was a suggestion by Dr. Perry, because he said that this is the language that's typically used, you know, in anesthesia. And so that was where we got that language from. That was his suggestion.
Okay. So good. We'll go ahead and add that in there before it goes out for public comment, as well as the hospice language, the carve out for hospice. Any other comments?
Real
Dr. Tibbles?
quick, Sharif.
Yep.
By the way, thank you for pointing out. I did say intranasal. I just want to point out, while there's not a lot, if any, really IV ketamine going on in homes, even in the hospice setting. It does happen in inpatient hospice settings, and then also you've got sub-Q and maybe IM, but sub-Q maybe at home, IV definitely in inpatient hospice settings, and maybe protecting against burdensome monitoring that can be intrusive at the very, very end stages of life. So I still advocate for kind of a carve out for hospice, but just wanted to clarify those key things.
Okay, thank you. Any other comments? All right, so right now we've taken direction to add those language, because if we're going to vote, I want to make sure that we're voting on something with the proposed language change. Scott?
Yeah, and that's what I want to check. And I think that's the question. The carve out for Dr. Tibbles is pretty straightforward. On the one with the immediately available, or do we want to say immediately on site? We need to know what the language is, because as Dr. Prashad, you were indicating that the language that is currently there must be immediately available was from the Texas Society of Anesthesiologists through Dr. Perry, whom you know, Dr. Zaffron.
But Dr. Perry actually was proposed also the on-site language also.
Okay.
He said, and his intention with that, he said, was in the building. That's what you guys
That
use
helps.
in anesthesia,
Yeah.
and that's why he said that. Yeah.
So that's why I was asking if Dr. Perry is present, but my understanding is that both Dr. Perry and Dr. Prashad are in agreement with the on-site language.
Yes. So if we were going to move forward on it, would be to adopt, to publish this rule today with the changes in this discussion being Dr. Tibble's exception and the clarification from Dr. Prashad with the agreement of Dr. Perry as our understanding. We could make those changes and we can get it to the register probably next week. It might be a little bit later with the holidays, but we could do that.
All right, very good. So with that direction, is there a motion from the board?
I'll make a motion.
Okay.
Go ahead, Dr. Jones.
Sure. Motion to adopt chapter
Publish.
170.
Publish.
Approve for publication.
Approved for publication. Thank you. With specific changes, including adding,
Including the suggested changes.
including suggested changes. We'll
Perfect.
workshop that.
All right. Okay. Is there a second on Dr. Jones's motion?
I'll second it.
Seconded by Dr. Bhatia. Any further discussion? All those in favor, please say aye.
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 All those opposed? Excellent. Thank you. Now, the next item, which is item 25, discussion, recommendation, and possible action regarding adoption of proposed rule amendments to 22 TAC, A, 161.48 physician graduates, B, 161.53 provisional license to foreign medical license holders with offers of employment. Before I hand it off to Mr. Freshour to make some clarifying changes, let me just mention that this is related to House Bill 2038, which is a groundbreaking piece of legislation that was passed by the legislature in 2025 regarding additional, not alternative, but additional pathways to licensure. Texas is the 18th state to pass some type of additional licensure process. And as I said, the intent for this is to, number one, deal with a shortage in the physician workforce. But number two, and that's why there are certain provisions in the provisional licensure to help address our shortage specifically in rural areas or in areas that have critical access to care issues. So that's the general synopsis. With that, I'm going to hand it over to Mr. Freshour to talk about some of the changes that are being suggested.
Right. And as you know, how the process works, today we're asking you to adopt these rules. They've been up for comment. We've been receiving comments since the last board meeting to date, and I'm going to do the physician graduates 164.48 first. Then I'll describe the comments in 161.53. But to date, for both of these, we've received in the neighborhood of 60 some comments. Now, on the physician graduate bill, this is the limited license. The rule is 161.48. The vast majority of the comments were from individuals saying the on-site supervision is fairly onerous, and what happens if my supervising physician's not there? Does the clinic close? And they've asked for some changes to that. Now, board staff's recommendation is not to make any changes to that because, again, this is a consensus rule. We worked through this a long time. We worked with state legislators, we worked with TMA, we worked with THA, we worked with civic groups, we worked with groups of individuals, we worked with some foundations that help supply some of our underserved communities throughout the state. So again, a consensus rule. Part of the reason that we want the supervision the way it is, and I say we as the board, but as the stakeholders were, these individuals, as you recall, are coming out of medical school. They probably more likely than not, and the intent of this is they didn't get into a residency program, or for some reason they perhaps chose not to go to residency but want to continue to use their medical training. But because these individuals have not had the proven training that we see with residents and that type of thing, and they have very limited clinical skills, as you all know, as physicians coming out of medical school, you have a great fund of knowledge, but the actual practice of medicine is you learn that usually in your residency or hands-on training. So again, because this is a new license type, the level of these people's skills and training is somewhat unknown. We recommend against changing any of the on-site supervision rules or the allowance of just one supervising physician with one alternative, because we believe that creates the flexibility. Some of the other comments were, do you want to increase the number of graduates a physician could supervise? And right now we limit it to 2 because, again, you've got to have the functionality. You probably need closer oversight than you would, say, over some of your other delegates. So again, we would discourage that. Some of the stakeholders wanted to allow as many as, similar to the PAs or APRNs, to allow 7 physician graduates under one physician. But again, we recommend against that. And we do, again, some of the individuals were worried about we had an on-site requirement. Talk about a timely discussion, Dr. Zafran. We have an on-site requirement for these supervising physicians. A lot of the commenters wanted to go to immediately available. And again, board staff is recommending no, you go with the on-site, because the individuals that are going to be availing themselves to this are not nearly as trained or anything else as quite a few of the IMGs that we're getting. It's not the same as a residency program. So again, we will summarize all these comments when we publish it, presuming you adopt it, but we are recommending no changes on the limited license medical graduate rule under 161.48 today. I'll be glad to answer any questions, or if you want me to go further into some of the comments, I can do that, but those were the primary comments that we focused on.
Great. I guess we want to take this separately? Okay. So with this, are there any questions or comments from the board members regarding the physician graduate rule?
Dr. Naidu, do they have
Dr.
any
Naidu.
CME requirements on these people?
He said, is there CME requirements?
Yeah, it
Yes,
should
there
be
are.
the same
It should be the same as with a licensed physician.
Thank you.
And that would include even the SB 31 CME that you guys just did a little bit earlier. Though
Yeah.
all those requirements would be there.
Any further questions or comments? Is there a proposed motion on this specific item for physician graduates?
I'll make a motion to
Good. Dr. Batu.
accept the recommendations based on the proposal for physician graduates.
To adopt this, right? We're going to
To
adopt this.
adopt, yeah, yes,
Okay.
of course.
Thank you, Dr.
I'll
Batu. Is
second
there-
it,
And I'll
Coconut.
second it, Farmer.
Seconded by both Dr. Naidu and Dr. Farmer. Any further comments? All those in favor, please say aye.
Aye.
All those opposed? Motion passes. The second item is 161.53, provisional license to foreign medical license holders with offers of employment. Mr. Froschauer?
Yeah. And again, we are looking for adoption today. This is 161.53. Again, received a number of comments here. We received about 60 here also, but a lot of those, they didn't actually submit comments. They just said in a favor of, or opposed, or neutral. But the comments we did receive did articulate in 3 areas where we recommend non-substantive changes and we think make more sense. And these comments came from the Texas Medical Association, along with the Texas Hospital Association and some individuals. If you look at 161.53 D5A and 6, this section said if employment is terminated of an individual holding this provisional license, they were supposed to cease practice immediately and give the board written notice within 48 hours of this termination. And that's repeated in 2 other sections on that exact same rule with the 48 hours. The proposal was that's administratively may be very difficult. We want to report to create accountability, but 48 hours may be too short. The proposal was for 5 business days. Board staff has looked at that. We've discussed it, and we think, given some of the administrative complexities that might go with it, that 5 business days would be acceptable. And we would, if you go to adopt it, we would ask for the adoption with the recommendation to change the 48-hour notice period to 5 business days where applicable. The second change was in 161.53E, and this related to the way the rule set up. An individual can have 1 provisional license, and if for any reason, something falls apart with the employment or the clinic, they can apply for a second initial provisional license. But there may be also the case where for some reason it just didn't work out in the first provisional. The rule that was written said an applicant for a second provisional license, which is the second step, because this is a 2-step process. It's a 4-year process. You have an initial provisional and a second provisional. When they get the second provisional license, that is when they worked in an MUA or a federally qualified health center, et cetera. But what this rule said was applicants for a second provisional, which would be their second 2 years where they're under less supervision in the MUA area, they must meet the general eligibility requirements, but they're also supposed to receive information from their initial provisional license, but they could have, or initial provisional employers. The way the rule's written right now, it says initial provisional employer, singular. But because they could have 2 employers if they got a second provisional, we're just asking to change the language to the plural form to ensure those situations where somebody had to get a second provisional. Right? So again, it's just language. When we said initial, that could theoretically be, well, the initial one, we're going to get the opinion, but we're not going to get the opinion from the second, provisional employer. So again, it's just a very simple grammatical change. The last change related to when they apply for a full license, they're supposed to have completed both the first provisional license and the second provisional license. The rule as written now said within 5 years. THA, TMA, and several commenters recommended 5 years is pretty tight because you're looking at, 4 years of training, but if there's a break or something happens, you might be pushed right to the 5-year limit and unintentionally exceed it. And do we want to exclude those providers from a potential full license? So what we're recommending there is, and again, because this is a new license type, to extend it to 6 years in the adoption with that amendment, and we think that should accommodate it. But again, being a full license, or being a new license type, I should say, with some unknowns, we want to be conservative yet accommodating at the same time, if that makes sense. So we're looking at those changes.
Scott, if I could also clarify.
Yes, sir.
On that 5-year period, I know we had a lot of discussion in staff about this. We were looking at that 5-year clock starting once, whichever, if they did one initial and they did a year of it and then it didn't work out for whatever reason, they had to start a new initial, that the 5-year clock would start with whichever initial they end up completing, if that makes sense. So the first one wouldn't count against them towards the 5-year limit. The initial, that 5-year period would start once initial 2 starts if they had a second initial.
Right.
Yeah.
And then we had some other comments, and one of the things is, and Dr. Zafran, I think you're probably going to talk a little bit about this, is one of the, and I'm just putting it out there, we're not asking for a change because we think the rule does it, but takes care of the issue. But again, this is a new license type. These are foreign medical physicians. We've got to verify some of their postgraduate training or their licensure status, and we anticipate we may have some difficulties. So some of the commenters were concerned because what we did was, in order to allow these individuals an opportunity at least to obtain those licenses, we said, if we can get verified credentials from your licensing country or those kind of things. But we put in as a potential alternate pathway, and it's not a default pathway, but it's an alternate pathway, is to get a competency evaluation through a program we approve, a K-STAR, a CPEP, a PACE, to ensure these individuals at least have minimal competence to then avail themselves to the provisional. But again, we built this in with maximum flexibility, and some of the commenters were like, well, does everybody have to do it, and how many times do they have to do it? And our answer is, right now, we've kept it intentionally flexible because we are going to face challenges in looking at some of their training. We've got some resources for us. We have ACGMI. We have several other vendors that do credentialing internationally that we're looking at that are interested in this. We can potentially look at, say, like Canadian licensing has its own international graduate pathway, so we may be able to rely on some of the Canadian verification. But we wanted to create flexibility, but kind of, if you can't do anything else, we may be able to, you may be able to avail yourself to this competency evaluation. So we definitely wanted to keep that in there, but to clarify, it's not default. It doesn't need a change in the rule, but it's very important that you understand that, because you may hear some conversations related to that particular aspect. I don't think there was anything else really that needed to be addressed in the comments at this particular point. So I'd be glad to answer any questions or turn it over to Dr. Zafran.
Yeah, thank you, Scott. And let me just emphasize that this is a very, very complex thing, because multiple different entities are involved, many of which we don't have any regulatory authority over. There's the ACGME, there's the ABMS or other potential board certifying entities, because there's talk of a pathway for board eligibility with all this, and trying to make sure that we are putting rules in place in a way that may not necessarily even address things that are already present has been something that the legislature gave us some discretion in. So keep that in mind as we're looking at this. We're trying to not only address the structure as it looks right now, but also potentially what things that we need to address as this program moves forward. For example, from a certification or validation of GME standpoint, because this is a new process where now you have almost the majority of states in the country either adopted or proposing to adopt this around it, the business models as far as verifying other entities outside of this country as to GME validity is still being put in place. And so we didn't want to hardwire a specific entity like ACGMEI, for example. They validate GME programs in 14 countries. I'm presuming, going to be adding more as we speak. But there are other entities out there also right now that are getting into the business of making sure that they validate GME programs. So what we have been looking at or proposing is to make sure that we have the ability to look at agencies or entities that have the ability to validate GME programs. And if they're from a place that doesn't, then we have a process in place to have an assessment on the qualifications of the individual physician who's declaring a certain specialty. So again, these are very specific nuances that we had to kind of figure out a way to make sure that we're trying to capture as many different possibilities as possible. Again, with the tricky part of dealing with entities that doesn't even necessarily exist right now. So again, I just want to make sure that you guys are looking at this from that viewpoint of why we put it together the way we did, with as much flexibility as we possibly could in how it's structured.
Yeah, and let me just be sure I'm clear on one more thing. Quite often, we write the rules as they are, but again, some of what we're talking about, what Dr. Zafran was talking about, such as who are we going to use or not use, they do not need to necessarily be in a rule, because it creates a hardwiring where then you've got to go through the entire process to add someone, delete someone. Much of this can be done as internal operations. We've set up, we're already working, and Mr. Carlton can address it, processes and procedure and licensure and how we're going to look at these things, how we are going to collect those documents. So all of this doesn't have to be in the rule, because we can operationalize these rules internally. And I think that one of the best areas is, as Dr. Zafran prescribed, looking at foreign credentials and what entities can do that and what fallbacks and processes we have. So again, rules are not necessarily to say, 1, 2, 3, 4 places are acceptable, because when you do that, that becomes the list. There can't be added to or that kind of thing. So a lot of this is going to be operationalized internally. So just keep that in mind when you're looking at the rules, that a lot of the sausage making happens behind the scenes. It doesn't have to be written into the rules, as long as the rules give us the proper tools to make those internal processes work.
Yep. One additional thing I would just mention before I go to the board members, just to make sure that this is clear also. In the first 2 years, it has to be an ACGME accredited facility or affiliated facility. So, for example, they may have clinics or surgery centers that are affiliated with that ACGME accredited facility. In the second 2 years, we're talking about entities that are under federally qualified health plans or designated as really underserved areas. Now, the way we structured this, and for a deliberate reason, is that an employer who is sponsoring the physician doesn't necessarily have to be that entity that is the ACGME accredited facility or the federally qualified health facility afterwards. There could be an employer, a physician group that is employing a physician that is sponsoring them, that is employing them, but where they work in that first 2 years is where it's mandatory to be at that ACGME accredited facility. They don't have to be employed by that facility. By definition, in many instances, they can't be employed because physicians can't be employed by a hospital, with specific exceptions. So that is a nuance that we had to build in, that you could be employed by one entity, even though you have to work with a restriction in that first 2 years in one specific entity, and in the next 2 years in another entity. Now, that doesn't have to be the same employer all throughout the process, hence why the language employers was entered in there. So again, I just wanted to make sure that I highlight the nuances, and I'm saying this out publicly so that it's clearly understood, before we adopt the proposed rules with the changes as to what that means and how it would be kind of proscribed as we go through it. So anyway, with that, let me go to Dr. Green for your comments or questions.
Thank you, Dr. Zafran. I have a couple of questions for Mr. Freshour and then one just kind of comment. Mr. Freshour, when you were saying that you wanted it to increase from 5 years, did you say the eventual number of years, or was that sort of malleable endpoint?
It was 6 years.
Okay.
6, yes, ma'am.
Okay, thank you, missed it. And then the THA had an interesting point that I was thinking about too, when it says that this provisional licensed physician cannot delegate anything. Is that right? At all?
Correct.
Like, does that mean if they want their patient to have a Tylenol, they have to go get the Tylenol out of the cabinet? They can't like have the
No,
nurse
we're
or
talking
MA
about, so we're talking about delegating the practice of medicine, Dr.
Okay.
Green. Like, for example, you can't delegate to a nurse practitioner or a PA to manage a patient in a hospital on your behalf, which obviously physicians can do without any restriction in a hospital setting. So that delegatory authority is limited for these licensees. You know, writing a prescription in a hospital to dispense Tylenol is an order that you are giving to one who can dispense it. And again, if I'm saying something wrong, Scott, correct me. But that's two different things. We're talking about delegatory authority, to where you're asking somebody else to practice medicine on your behalf that you deem qualified to be able to do so. A fully licensed physician can do so. This physician at this period of time wouldn't be able to.
Okay, I think the THA must have misunderstood then. And then the other thing was that it talks about board specialization, but the term would be board certification. Like, it's just the wrong word was used.
Where was that? I'm sorry, doctor.
Oh, I'm gonna have to find the page. Hold on, let me see.
I was gonna say it's gotta
I
be.
got it. It's actually in a few spots.
Okay.
Yeah. It's under E9, it's twice.
Okay.
And I think it's correct for this particular purpose. It's if a pathway to board specialization exists.
Yeah.
But I will defer to you guys if y'all want to change it to
Yeah, no,
certification.
that's your eligibility language.
But,
doctor.
but you're eligible for certification.
No. So it's a pathway to board eligibility. Remember that you have to be eligible.
Mhm.
You can't force somebody to be board certified in Texas, but this is a pathway to board eligibility that gives them a pathway if they so choose to become board certified. So I don't know if the correct language needs to be board eligibility. Probably needs to be eligibility, because that's what typically folks are so we can change, to your point, Kelly, from board specialization to board eligible or board eligibility.
Thank you.
And that is actually, I think, at the very end, I believe. Where is that again?
It's E9. Yeah, it does end with if a pathway exists, the certification granting organization must submit a letter on behalf of the provisional license holder of satisfactory progress towards board specialization eligibility. So again, it may not exist today, but in the future.
So there's terminology, board specialization eligibility. So that's a nuance that's talking about being specialized in a certain specialty, but to be eligible to be able to do so. So I think so long as the word eligibility is in there, it should be able to cover it.
It's also under G3.
Yeah. Okay, is that it, Kelly? Okay, I believe Ms. Villarreal? Lisa?
Thank you. Yes, really quick on the terms, I was just curious why we landed at 6. What are other programs around the country doing? I thought I just read in some of the comments that they're more likely to go to 10. So I just was curious about that. And Scott, also, we did, oh, sorry.
That's USMLE, that's different.
Just double checking.
Oh, okay. I was like, that was nervous that we were overly strict, because we did get comments from a state representative about perhaps being overly strict in the rules, and I just wanted to understand.
Yeah, let me address that, because I've had those conversations also. First of all, the USMLE eligibility still is 10 years.
Okay.
We're talking about, remember that the provisional license is 2 years and 2 years, which is 4 years.
4.
We're talking about the possibility of something happening in between where an institution closes and they have to look for employment to open and all that. We wanted to extend that period of time so that they didn't fall into a trap where, you know, there's some flexibility in being able to complete that 4 years. So it's 4 years within the 6 years, but the USMLE part is the 10 years. Regarding the restriction, and I think that came about because of the requirement of possible evaluation or assessment that we put in place. But again, let me emphasize that this is a structure that a lot of the existing qualification and validation entities don't exist. When you're looking at a medical student who is applying for residency, there's the ECVMG certification requirements, but there's also making sure that the medical school meets the standards that we would accept. And if they don't, we have additional processes in place to ask the medical school to provide for the courses, et cetera, et cetera. And if they don't, there is no pathway to licensure unless they become licensed somewhere else and then they become board certified and then they have that pathway. Here we're talking about evaluating a GME program, a graduate medical education program. Now that involves making sure that there's equivalence in the number of years, but also equivalence in the amount of training that they've had at those programs. If it's a general surgery program, did they have enough training to do enough appendectomies, enough cholecystectomy, whatever that might be, that a residency program here would ask a participant to do in order before they would graduate from that residency program and become board eligible. So if we have entities out there that may help fit that process of validating them. ACGMEI is one of them, and there may be others that we would deem qualified to help us in certifying that the GME program is qualified. Now, let's presume that there is a person coming out of a GME program that doesn't fit into any of those categories.
Right.
They're not part of an ACGMEI certification, and there's no other entity that we have certified is qualified to certify that GME program. Now, we can say you're not qualified to even apply, but we don't have that discretion. So we have to at least put them through the process. So the assessment part is a way to assess that that person is qualified to go through the program, provisional license program, in the specialty that they're declaring, whether it be orthopedic surgery, remember that this is a very new process where we are now allowing, even though it's in a limited setting, folks to be able to practice medicine in a specialty. And so we wanted to be extra cautious in making sure that they're qualified to be able to do so. So the assessment part is, in the absence of any of that others, we have a way to be able to assess whether they are qualified to be able to do so. Now, we had suggested that K-STAR could be one means of assessing them, but that doesn't mean that there aren't other means of assessing them that we could deem are qualified to be able to do so. Scott, you may want to add.
Now, I'm going to just jump in and say, I think the summation was done very well by Representative Oliverson, and there was another representative at our stakeholder meeting. The intent here is, let's create access, but we do not want second-rate care for our citizens. We want first-rate medical care. So again, that's all the things that Dr. Zafran is talking about that we're building in here. And this is new. It's, so there is going to be some learning process. But again, the emphasis was patient safety, not second-rate care. So again, that's the underlying theme that drove this whole thing, and Representative Oliverson articulated that probably 14 times in his presentation to us.
Yes. Ms. Troncoso.
Thank you. So my comments were somewhat along the lines that Louisa was on, but so two comments. I did receive comments from a state representative that talked about the concern over substantially comparable, or whatever the language was, associated with being able to verify those programs. And I don't know if it's our intent to be able to say, and maybe it's 2 years from now after we've done this, we're able to say, these are what we're using, but you're welcome to submit your own thing. So I appreciate the explanation on that.
Yeah, so Linda, just to kind of highlight, that's exactly what we're talking about. There are entities, like I said, like ACGMEI. And remember that these states have just passed these laws recently. There wasn't a reason for ACGMEI to have a vetting process because there was no reason to vet them. So now ACGMEI is doing it, but there are others that are doing so. So that's where we're talking about as to a substantially equivalent program from the standpoint of number of years. because if you have a general surgery program in one country that says we're going to graduate these guys in 2 years, that from a very beginning standpoint is not substantially equivalent. Now, if they graduate in 2 years and practice in 3 years, and again, there's nuances that we would need these entities like ACGMI or others that are coming down the pipeline to help us to make sure that we are putting folks who are qualified out there to be able to go through the process.
I appreciate that. The second comment that I did here was during the first provisional license, if they don't complete the 2 years in its entirety, they lose credit for that 2 years. And the thought process that is actually described, it's on page 3. It is D9. If a provisional license holder does not fully complete their initial provisional license period for any reason, they will receive no credit for prior initial provisional practice time and may reapply for a second provisional license or may be required to appear before a board licensure committee. And so my thought process was things happen to people. You have a life-changing experience, you have a medical issue, you're in a car accident and break your leg and you can't show up to work for a while, whatever the case is. I think there are opportunities where I would hate to see somebody lose at, month 20, their opportunity to get credit for that issue. And so I don't know how we address that.
If you look at K, look at K.
Yeah, that's the one that says that the executive director may approve reasonable deviations from the required provisional timelines due to extenuating circumstances. So we did think we had a lot of conversation about this too, and it was hard to say, okay, well, how do we put this in the rule where if this happens, then that happens, and this gets credit and that doesn't? So we do want people to, it's going to be case by case basis. They can submit, and obviously, if someone misses, the last 2 days of 2 years, they're not going to have to start 2 years over again, type thing. But we want to make sure, what happened, why did they lose the position? Is there a way for them to?
Hence why we said the licensure committee is going to have a lot more fun moving forward.
And the other part of that, the other part of that, Ms. Troncoso, is what Mr. Carlton was citing, but also Mr. Carlton and I spent an inordinate amount of time working through this, but there is, if they lose employment right in the middle of something, we also give a 60-day extension of a tolling period for them to get new employment. And again, I think your point's a little bit further down the road, but the other reason, and I think it's important to address that here, is we did already build that 60-day extension in where if you lose employment, we're going to toll you, and then within that 60-day window, if you can get employment, you're going to pick right back up so you don't lose that credit for, say, that period of time. The reason, and one of the commenters, and I know you've all seen it, were, why 60 days, why not 90 or a little bit more? The 60 days was relative to visas because the federal law talks about work visas and a 60-day grace period. So we're paralleling the federal law under the presumption that if they're here under authority to work in the United States, we can't give them more time than their authority to work. So that's the other reason when you see that 60 days. So let me just answer that preemptively.
But if they are a green card holder or a citizen, then that's where the discretion of the executive director comes place. So there is a mechanism to deal with that depending on the circumstances.
Okay. Thank you so much.
All right, Dr. Naidu.
Yes, sir. I just wanted to understand a little better. The corporatizing the practices, will the hospitals misuse them, appointing these people, 3 or 4 cardiac surgeons coming from Poland or from India, and then directly competing with the cardiac surgeons who are trained here, having a lot of loans? And the hospitals are going to take a big advantage, and the corporatizing the practices will be more on the specialties. I don't know about the quality, but definitely the hospitals in everywhere where it's got whatever you're talking.
So a big part of this
flood of the doctors.
Yeah, so a big part of this debate happened with the passage of the legislation. So we're kind of way past that right now. That was a debate that happened at the legislature. Our charge is to now implement what the legislature passed. As far as concerns regarding, misuse of licensees, they are our licensees and they are able to complain to us if there is potential misuse, whether it's by another licensee or anything else. So even though they're provisional licensees, they still fall under the regulatory authority, the medical board, and can file complaints as such. I don't think there's any ability for us to control every single scenario ahead of time. I think it is important to be mindful of the concerns that are raised and work through it through our regulatory process. If we need to make changes, then we can always do that afterwards. But the validity and the skill set, I mean, that's why we're kind of going through all these processes of vetting ahead of time. But the debate about the overall thing, we're already way past that. This is more of an implementation part right now. The passage, that was a statutory thing. We're in the implementation side of it right now.
Got it.
Any further questions or comments?
And sorry, and Scott, sorry if I missed it.
Yeah,
Did you?
I have.
Go ahead, Dr. Batu.
First of all, we still have the ability to discuss it and accept it or reject it. It's not just implementation just because that's what we've been directed to do. We have the option to not accept it in the form it is, and I think it's a valid point that Dr. Naidu brings up, number one. Number two, is there any provision that, and I think you talked a little bit about it, Sharif, already, in terms of location of where these initial licensees would be having to practice that. And the reason I'm trying to describe it in the way I'm thinking, hospital systems, let's just say here in Houston, there are hospital systems that have multiple satellite or various hospitals in different locations, but the training portion of that system is only in one place. Okay. So if somebody comes and says, okay, I'm going to be under the ACGMEI or training under this particular facility, are they mandated to only stay in that hospital where the approved training program is, or will they be able to go to work at other facilities that may not have training facilities, but that are still under the same system that holds the training facility?
It specifically says, it specifically says affiliated facilities.
Yeah, but I mean, but that doesn't protect anybody from going to practice, say, in the Valley under a hospital system that the training program is in Houston or Dallas or wherever. That to me doesn't seem safe.
But the statute allows that. That's not something that we have discretion over, Devinder. And the other thing I would just mention is that, yes, we have discretion here, but there's another superseding requirement that this has to be implemented and move forward by January 1st. That we do not have any kind of discretion over.
Well, then why are we even discussing it?
Because we can make changes. We are taking the comments that are being proposed in kind. If they're substantial, then we can't make those changes. We would have to pass it as is and put potential changes as a possibility moving forward. But we have to pass something today. That's something that we don't have any discretion over.
Well, I do have an issue with the term affiliated facilities on this particular proposal, because again, where's the oversight and supervision if somebody, like you say, may have practiced already, in another country, who has, maybe the ability to practice cardiac surgery or anesthesia or whatever, but they have to come to the facility that has a training program, but then they're shipped off to another area where, there's no portion of the training program in those hospitals. And I know that is the case.
Well, I don't think, go ahead, Devinder, sorry.
I'm just saying that, can we just say, I know there's a training program in Kingwood. That is the training program. There are no other places where those people train. And so if, there's nothing wrong with that, except for if you put somebody that comes in from another country who has an approved license or whatever to be under this ACGME training facility in that particular city, but then is shipped off to another area where there is no training program. That's just, to me, where I have a little bit of heartburn, because our challenge, or what we've been told, is we need to protect the public, right? To me, that doesn't seem like you're protecting the public.
So Kingwood is a facility.
An unserved area that may not necessarily be part of the training program within the facility. You know what I'm saying? Within the system.
Yeah, so Devinder, let me just try to clarify this. Kingwood, if you want to use that as an example, is a facility.
Yeah.
There may be a hospital, a medical office building across the street from Kingwood that is part of the affiliated facility. It doesn't say affiliated healthcare system. Kingwood is an ACGME accredited facility, but Northwest or Tomball is not.
Correct.
I don't think you can say that. I don't think that's an affiliated facility. It's an affiliated healthcare system maybe, but it's not an affiliated facility. So I don't think you can say that that the person who's in Baylor Scott and White in Temple can go to an affiliated healthcare system down in the valley, because that's not an affiliated facility. So I think the term facility was used deliberately so that if you're seeing patients in an office building that's across the street, like a lot of residents or faculty at, say, UT Houston or UT McGovern do, it's, their facility is Memorial Hermann, the medical center, but there's a professional building across the street. There may be a surgery center that's affiliated with it, that is affiliated with that facility. But that doesn't mean if you're Memorial Hermann, the medical center in that facility, that all of a sudden you can go to Katy, which doesn't have a ACGME facility in itself over there. So I think facility was used deliberately and not system from that standpoint.
Yeah, but I think that needs to be very much delineated before we just say, well, it's across the street or whatever. I think because what you will get is that, oh, well, it's in our system, so it's by definition it's affiliated.
And Dr. Bhatia, on that, the statute does say, or an ACGME affiliated setting. And again, this is some of the things that Grace and the licensure folks do that we have here is we have tons of the affiliation agreements, and we know what settings and everything are affiliated with that. And I take a little privilege here. Dr. Martinez, you might have something to say about that, since you work in a residency program pretty extensively.
Yeah, I think that I think Sharif has it right about the way they use facility. I think the important point here is to Dr. Bhatia's point, they're not just going to get sent anywhere. There has to be a formal affiliation agreement between those two places as a safeguard. So they can't just send somebody somewhere, because usually the ACGME, the insurance company, Joint Commission, whoever else requires an official affiliation agreement between the two.
And so do we.
As long as all that is laid out and made clear, I don't have a problem with it.
That's part of internal operations. That's part of internal operations, because the statute itself says affiliated entities. So we are bound by that. But in our internal operations of how we delineate that part can be specified in there. The rule is mirroring the statute itself when it talks about affiliated entities or affiliated facilities. As we look at those agreements, as Dr. Martinez alluded to, that can be looked at as far as the internal operations are, to make sure that they have that those affiliations are not just a haphazard affiliation, that it's an actual formal affiliation.
Okay.
Dr. Martinez, your hand's up.
Yeah, no, I was just gonna mention, I think that's where the issue was, because if you remember, Sharif, like we not got in trouble, but we had to figure out a way in licensure. We were getting a lot of people coming over that were doing medical school, pediatrics rotations, but they were a non-affiliated you know, they were in a non-affiliated program, we were having issues with that. So, you know, that's something we need to look at. Obviously, I think that's where some of this will be solved, is that there's a formal affiliation agreement between the two parties or wherever.
So the affiliation language is in the rule. You know, as we operationalize it, we can very specifically make sure that there is an affiliation agreement as it's defined as to where those folks can go, that it's not just a haphazard place, that it's not just a loose term, that it's something that we define. Anyone else? All right.
Is there one more question? Is there any terminology that would render some sort of equality in terms of I don't know. I guess we can't. I don't know if we can control what these doctors are paid. Should they be paid the same as?
We can't get into that. That's not something that we can prescribe and rule.
Yeah. Okay.
Anything else? All right. With that, you've heard the discussion and the comments and the proposed changes as based on the comments that we got in the comment period. Do we have any motions out there right now? Staff is recommending to adopt with the changes that were proposed based on the comments. So I just need to hear a motion.
I'll move
This is
to
Harriet,
adopt
that we accept the provisional license to foreign medical license holders and offers of employment.
Thank you, Ms. Harrod. Is there a, we're adopting the rule 150. Yeah, we're adopting rule 161.53 with staff changes.
Correct.
I'll second the motion, Kokonos.
Okay, motion made by Ms. Harrod, seconded by Mr. Kokonos. Is there any further discussion? All those in favor, please say aye.
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 All those opposed? Motion passes. Congratulations, everyone. This was a monumental task. A lot of work by everybody and a very, very healthy debate by our board members, which was very appropriate. And I think it gives staff some direction as they're putting the operational processes together. And as we mentioned, there may be changes later on that we need to come back and revisit. So that would be completely appropriate. So, all right. Agenda item number 26, there's none there. 27, there's none there. 28, there is none. 29, there is none. And 30, there is none. 32, there is none. And let me just go to the consent agenda. I'm presuming we're ready for that. So can I have a motion on the consent agenda?
Move for approval of the consent agenda, Martinez.
Second.
So item number
Second,
one.
Barnes.
So item number one, consideration approval of the October 17, 2025 medical board meeting minutes and action items. And number two, committee reports and the consideration and approval of minutes and action items of committees meeting during the board meeting. Is that your motion?
Yes, sir.
Okay, motion's been made. Is there a second?
I'll second Harrod.
Any discussion on the consent agenda? All those in favor, please say aye.
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 All those opposed? All right, consent agenda is passed. All right, now I'm going to go back to agenda item number 31, which is open forum for public comment. I'm going to hand this over to Mr. Carlton to make sure everybody's aware of what the rules are and go from there.
All right, we're here towards the end of the agenda. It feels like it should be a lot later than 11:16, but you guys have covered a lot of ground today and a lot of good work. So thank you for that. For the public comment section, as you're aware, but if those of you that's your first time here, this is the opportunity for anyone to make a comment to the board. Your comments will be taken in the order that we see your hands go up. You will be limited to 3 minutes in making the comment. We have one member of the public here in the room. Not sure if you were intending on making any comments or not. No comments, okay. So it'd just be individuals online with us. Again, you'll be limited to 3 minutes. It is important to remember that the board is limited in what type of response it can give during the public comment section, since these are items that are not necessarily on the agenda. So we will go, it looks like first up, we have Senator Bob Hall. Welcome,
Thank you.
and your 3 minutes will begin.
Okay.
I thank you for your consideration of this very grave concern I have with regards to the unethical, misguided, and damaging behavior of the Texas Medical Board that continues to be a blight on Texas. Now, I'm not going to cover all the misdeeds by TMB and SOA and some of the shameful actions. Those will be covered in a report that I'll be putting out later. TMB has squandered far too much of the taxpayer money on this farce of a kangaroo court and on a non-issue just to satisfy the overinflated egos with serious conflicts of interest. Not one more minute of time or one more dollar should be spent on this case, period. The process by which TMB operates is so egregious that there is great concern that their misguided actions in general and in the Dr. Bowden witch hunt will not reflect well on our governor and the state legislature. These are just some of the top bad behavior issues. There is a great deal of hard evidence supporting each of these and more. 1, the TMB executive director lied in the 2025 Financial Committee testimony on the Health and Human Services Finance Committee when he reported that ivermectin was not a consideration in the charge. He reiterated what Dr. Zafran had said many times. Dr. Zafran lied multiple times about ivermectin, and when he lied in the first hearing by purposely mischaracterizing ivermectin as a dangerous drug. Yes, it is by definition because it's a prescription, but it is a drug. But the intent of the message was to relay that Dr. Bowden had been doing something dangerous to a patient. Ivermectin is far less dangerous than aspirin or Tylenol. And in the complaint itself led with, it is alleged that you prescribed ivermectin. If that had been Tylenol or aspirin, nothing would have been done. So this charge is all about the use of ivermectin. Board members were exposed having preconceived biases against Dr. Bowden in a series of messages sent even before the board received a complaint. The board approved filing a case at the SOA under false pretense.
Senator Hall, you have 30 seconds left.
I was told I would have whatever time it took to take. I'm
not sure who relayed that. The public comments are limited to 3 minutes, sir.
I know you don't want to hear it. You know, the really sad part about this is thousands of doctors treat COVID patients with ivermectin hydroxychloroquine and had 90% of their patients live, while hospitals like Hughley managed to kill most of their patients because of the hospital following protocols that netted them more money than they did in the health. There was nothing that Mary Bowden did that deserves the treatment she has or the taxpayers for you guys to be wasting this money on them.
Senator Hall, thank you for your comments. Senator Hall, thank you. Senator Hall, thank you for your comments. Your time is up. Thank you. Okay. Anyone else? Is there anyone else that has public comment for the board at this time? Okay, not seeing any other hands going up. We'll give it another few seconds. And double checking just in case, as always, if there's anyone that's joined us by phone only, you just state your name. Or I believe you dial *6 to unmute yourself. Okay, not seeing any others. I believe that'll complete this agenda item.
Thank you. Okay, before I get to the last agenda item, let me just say again, and I've said this before at the last meeting, we don't pick and choose what laws we enforce and what we don't enforce. If that was the case, we would need direction as to what law is appropriate to enforce and what law is not appropriate to enforce. In making charges, you know, obviously that is not an option that we have. We don't have that discretion. We don't get to make that decision as to what law we enforce or what we don't. And what I've said before, again, is that regardless of what the medication was, giving it in a facility that you're not credentialed at has and always was the issue, regardless of whether it's ivermectin, which is a drug that is available over the counter, and that's fine. Even as an over-the-counter drug, if I try to give rubbing alcohol as a prescribed treatment to a patient in a facility that I don't have privileges at, that's still a violation. It has nothing to do with the drug. The allegation involved the drug because that was the drug that was trying to be given at a facility that she was not credentialed at, but it had nothing to do with the drug itself. And I know everybody keeps on trying to characterize it that way, but no matter how many times that's being said, that was not the case. We do not choose whether a drug should be given or not unless it is a drug that is going to be fatal. We won't allow a physician to give cyanide to a patient. That is not appropriate. We will not allow a drug like potassium chloride to be given above a therapeutic amount because it will kill a patient. Those are things that we can mandate, but so long as somebody is consented to a treatment, they are free to be treated however way they choose to. In a credentialed facility or a facility that you have to be credentialed at, that has to be by someone who's credentialed to work at that facility. And I think there was an allusion by one of the board members as to why that is the case. You know, I can't just walk into a facility and say, you know what, here's a abortion-inducing drug. Have at it. That wouldn't be right. Number one, it's illegal. Number two, how are you going to stop that if you can't regulate who's giving medications and who's not giving medications at a hospital? There's a reason for that. It has nothing to do with the drug itself. It has to do with managing a patient's care that can involve giving a medication, or it can involve prescribing a certain treatment. Like if somebody has an ear replacement and they have to have an extension and a flexion, 5-6 hours a day, Dr. Vanderweide, who's a neurosurgeon. I mean, that's a prescribed treatment that, again, would not be allowed to be done by a physician that is not credentialed at a facility, even though it does not involve any medications whatsoever. So I just want to make sure that that is absolutely clear. Mr. Carlton did not lie. I think he made it very clear that ivermectin was not the issue. It was the medication that was given by the physician in a facility that she's not credentialed at that was the issue. And when we talk about medications in general, prescribed medications are described as dangerous drugs. I'm sorry, that's the way it's described in law. We have to describe it that way. We don't have that discretion in putting these descriptions in there. I know Tylenol can be dangerous if it's given in very high doses. I know aspirin can be dangerous if given in very high doses. Walking out the middle of 6th Street at night can be dangerous if not done appropriately. We have to describe things as they are. That doesn't mean that we lied. It doesn't mean that we're not doing things appropriately. It means that we are following the law as the legislature has directed us to do so. So anyway, that's what I wanted to say. I hope everybody has a very Merry Christmas and a Happy New Year. And with that, I will take a motion for adjournment.
I move that we adjourn, Harrod.
Second.
Motion by Ms. Harrod, seconded by Dr. Bhatia. Is there any discussion on adjournment? Seeing none, all those in favor, please say aye.
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 All those opposed? All right, meeting has ended on December 12th, 2025 at 11:25 a.m. Merry Christmas and Happy New Year, everybody.
Merry Christmas.
Merry Christmas.
Merry Christmas.
Merry Christmas, everybody.
Bye-bye.